नॉर्मली जाती हूँ 2 मिनट में।
Hello, good morning everyone. Vidya dadati vinayam, vinaya dadati patratam, patratva dadati mapnoti, dhanadmam tatah sukham.
हेलो, सुप्रभात सभी को। अर्थात ज्ञान हमें अनुशासन प्रदान कराता है। योग्यता अनुशासन से आती है, धन योग्यता से आता है। अच्छे कर्म और धन का परिणाम है और अच्छे कर्म, अच्छे धर्म कर्म हमें अच्छी सुखी और संतुष्टि प्रदान करता है।
Good morning everyone. I Himadri Pandya, young professional.
सुप्रभात, मैं पल्लवी, young professional.
Welcome you to the National IP Conference 2023, Day 2. With a powerful start yesterday to the event by being acronymed as the Innovation Powerhouse, having immense potential, here we are at Day 2, carrying forward the same energy. With this, I start the session for Day 2. Today here, we have a session on IP policies and enforcement or litigation. We are here to discuss about IPR policy, combating IPR infringement, dispute resolutions in IPR, and enforcement challenges in IPRs related to futuristic technology. To deliberate on the same, we have an eminent panel of learned professionals. First, Honorable Ms. Justice Pratibha M. Singh ji, Chairperson of IP Bench, Delhi High Court. She will be chairing the session for today. We also have today with us Amok Dev Rai ji, the founding director of Sanrachana Foundation. Along with, we have Shri Narendra Sabharwal ji, former Deputy Director General of WIPO and IP advisor to FICCI. And we also have with ourselves Shri Rajiv Srinivasan ji, former member of IPR think tank. We welcome all the panelists on the stage. I would request Shri N.R. Meenaji, Senior Joint Controller of Patents and Designs, to please felicitate the chair for the session, Honorable Ms. Justice Pratibha M. Singh ji. I request Shri N.K. Mohanty, Shri N.K. Mohanty ji, Senior Joint Controller of Patents and Designs, to please felicitate Shri Narendra Sabharwal ji. I request Dr. Dinesh Patil, Joint Controller of Patents and Designs, to please felicitate Shri Rajiv Srinivasan ji. I request Dr. Sunita Bedgiri ji, Deputy Controller of Patents and Designs, to please felicitate Shri Amog Rai ji. Thank you so much. Before starting the session, let me introduce you all to the eminent panel that we have with us today. Justice M. Pratibha Singh ji. Justice Singh completed a 5-year law course from the University Law College of Bangalore. Okay. Thank you so much. I would now request our eminent panel to please begin with the session on IP policies and enforcement and litigation. Thank you so much. Ma'am, we request you to please chair the session and start.
Okay,
Thank you so much.
A very good morning, and thank you for skipping the introduction. I think we are in a hall full of friends from the IP Fraternity, and I guess a lot of us know each other, and we could use the time for more effective deliberations rather than to have an introduction. A very good morning to all of you. This panel, as you may see, appears to be obviously a newly constituted panel. I think one of my colleague judges could not make it due to some medical issue. And it's always a pleasure to firstly sit with Mr. Narendra Sabharwal. Sir and me have had the opportunity to work so intensely on the IP policy. Mrs. Sabharwal, of course I have to say, you are sir for all of us. He's had such a long experience in the IP industry as a bureaucrat, as a technocrat. He's been part of several negotiations, but his last contribution as part of the IP policy with all of us was such a learning experience for me and for all my colleagues. And I'm sure Rajiv will bear me out. Rajiv Srinivasan, who served with me on the think tank. We have Amog Rai from the Sanrachana Foundation. He said he's an economist. And I wish we can have more economists in intellectual property, because we miss them in intellectual property. And there's more and more need, and I keep saying this again and again, that we need accountants, we need economists, we need physicists, we need chemists, we need molecular biologists in IP, and I'm sure some of you in the audience are already one of those, which I'm not, definitely. I didn't even have a science background, so it's okay. Let's look at the topic for today, firstly, and that is nurturing growth of IP for a knowledge economy. I must say, knowledge economy, I heard for the first time from Rajiv Srinivasan on the IP think tank. He is of course, working with a large number of startups, incubators based out of Kerala. And I'm sure he'll be speaking to all of us today. But before we do that, I would like to just give some opening remarks on the journey that India has had in the last few years in intellectual property. Some of you may already know it, and some of us need to be told that the journey has been such a difficult one, but with several milestones. And the reason why we need to remember this is because a lot of us in the hall today and even outside have contributed to this, including, of course, our Controller General, who was also on the think tank with all of us, on the IP think tank when we drafted the policy. So the vision for the policy and what we've achieved, I'm sure Sabharwal ji will be, speaking about it in his remarks. But one thing I can say is that this is definitely a policy which has not remained on the paper. A large part of it is implemented or is in the process of implementation, but there's also some bits of the journey which we yet have to undertake. So we can actually divide this into the past, the present, and the future in the IPR policy, and there'll be so many milestones that we can all write about, talk about, and cherish and remember what are all the goals that we need to achieve. This is as far as the policy and the administration is concerned. So the slogan, Unnat Bhai, you've violated the copyright of the think tank. Creative India, Innovative India. It is part of the policy. This was the slogan which was coined in the policy. And I'm so glad to see it on the brochure today. Insofar as policy and administration, we'll be having a deeper discussion with everybody here. But let's also see something more that has happened in the enforcement side. The policy itself had its own, as you may say, impetus for intellectual property, but the contribution that the judicial system has made in India for intellectual property is unparalleled. Whether it is in the form of injunctions, seizure orders, trademark owners being protected, piracy being stopped, patents being enforced, the judiciary has played a very important role, of course with the help of the bar and the lawyers and the IP stakeholders in general. And we see a growth in Indian IP litigation which has never seen before. I'll give you a few statistics to just make you understand what has actually happened in the IP sphere, in the judiciary. As you all know, we had the IPAB, which was functioning till 2021, and the 2021 Tribunal Reforms Act saw the abolition of the IPAB. And I must confess that it was a complete bolt out of the blue, for all of us at least. I didn't know about it. I'm sure many of us didn't know about it. And when it happened, we were not sure as to how the IP ecosystem would even, move forward. And whether it's in the commercial courts, whether it's in the high courts of the country, we saw 3 or 4 major changes which took place in IP enforcement. The first, according to me, would be the Commercial Courts Act, the 2015 Commercial Courts Act. That act completely changed the way commercial litigation is seen in this country, and the way timelines were fixed, and everything had to move in a timeline manner without, lot of scope for delays and etc. And my own experience even before 2021 was that under the Commercial Court Act, the law became so stringent that defense, written statements, witnesses, cross-examination, actually it was possible to conclude commercial cases within 1.5 to 2 years. And this is the experience we've had in the Delhi High Court, while whether we've seen cases within the commercial division of our court, or whether we are seeing appeals from the district commercial courts. And let me tell you the reason why this has happened. Most commercial cases are getting sorted, out of which IP is a bulk. At least 60 to 70% of commercial litigation in the district judiciary belongs to the IP sector. And in those cases, the reason why we see quick disposal in commercial cases is that there has to be a written statement or a defense filed within 120 days of the service being effected on the defendant. And this timeline has been held to be mandatory by the Supreme Court and cannot be relaxed. Because of that, we realize that in practice what happens is, whenever a defendant does not have a very good defense, usually they used to take adjournments and things like that, and it would get delayed. But now with the timeline being fixed and mandatory, most defendants tend to settle the matter out of court. So commercial disputes, almost 40 to 50% of them get settled at that stage itself. So they don't proceed to trial, and they make use of mediation, conciliation, kind of alternate dispute resolution, and it gets settled, which I think is a very good conclusion for commercial disputes, because people who are in commerce don't want to litigate. They're happy to have their cases settled and move on. And this is a good trend that I saw. The second trend that I saw is at the stage of trial. Most commercial cases don't go to trial because there is a very big kind of roadblock which is there, which they have to cross, and that is relating to documents. What happens to documents which were filed by the plaintiff or the defendant, in earlier times prior to the Commercial Court Act, we would have had documents being denied by parties very easily, whether it was legal notices, emails, invoices, purchase orders, all these kinds of things. Trademark registrations, they would deny. So the plaintiff had to prove even a trademark registration, which is so easily accessible online, or a copyright registration, or a granted patent. These things would never be admitted by the defendant. But now, because of the process of discovery, inspection, and admission denial, which is a very strict, again, procedure, most of the documents get admitted at that stage. And once the documents are admitted, it's very difficult for the parties to resile out of them, and therefore the trial is completely reduced. This has made a big difference in trials being, concluded or not proceeded with, and therefore commercial court cases do get decided very quickly. And even in those cases where the matters proceed to trial, the witnesses are few, one or two witnesses from both sides, and the cross-examination, the court can fix the time. And so we are seeing a large number of commercial disputes being resolved between 1 to 2 years in the commercial courts, in the Delhi commercial courts. Now let me give you the experience of the Delhi High Court, where we have a large amount of commercial disputes. In Delhi High Court, commercial disputes, every month we get about 100 or 125 of them. And out of which 70% is IP. And 70% of the commercial disputes being IP, at least a large number, trademarks, copyrights, you take it from me, 90% of the cases don't go to trial in the High Court. Which just shows how, its Commercial Courts Act has had a major impact on how IP litigation is dealt with. And the second thing that has happened is the Supreme Court has held that in commercial court cases, costs are mandatory. So when the defendant knows that he can be saddled with costs in a big time, sometimes in commercial court matters, in trademark matters, we've awarded costs like 30 lakhs, 40 lakhs, 50 lakhs. Actual cost statements are brought, and if the case has gone to trial and if the defendant is losing, so then the defendant knows very well that the saddling of costs can be a very big deterrent to the defendant. And I think coupled with strict timelines, strict document procedures, and strict costs, 90% of trademark cases are getting settled. Most cases don't go to trial. And in my earlier experience of heading the IP division in the Delhi High Court, and my current experience from July being in the Delhi High Court IP division, I can tell you that issues have not been framed in more than 10 cases which have been handled by me, which is stupendous. I mean, I would really be surprised if I heard these statistics from someone. Issues are not being framed. Mostly it's the patent cases. The trademark and copyright cases, therefore, are reaching fruition very quickly. Less than 6 to 9 months, less than a year, the case is over. In the mediation which takes place, most of the times the plaintiff is reimbursed with costs, or at least partial costs. So we are moving in a trend which is, which is very positive for IP owners. And I think that going forward, if this trend continues, it won't be long before, IP cases get resolved within 3 or 4 hearings. This may not be the story of patent litigations, but. So in patents, the pharmaceutical cases, the standard essential patent cases are the cases which are mostly heard in courts. But I must say there's a very distinct trend of startups suing big companies now. There are at least 3 or 4 cases in the last 4 months which I've seen. And there are also some very interesting cases relating to non-essential patents as well, such as mechanical patents. So I heard the first GI Act infringement last week. So we are now seeing a consciousness on even non-trademark, non-copyright cases. And I think patent cases are going to trial, which is a very good thing. In one of the cases which the division bench decided recently, Nokia versus Oppo, the division bench directed a huge amount of money to be deposited. And I can't even reveal the numbers which are, they're in millions of dollars, the amount of money that's being deposited in courts in standard essential patents. and contemporaneous litigation is taking place in the Delhi High Court, and the number of filings in patent enforcement actions, we have at least 100 infringement suits every year in the Delhi High Court on the IP division, which is a huge number. So I think the last comment that I would like to add as an opening remark, though I took some time, is because I think the trends of IP litigation need to be known to this audience so that you can spread it. And the biggest challenge that IP faces, according to me, is the internet. Every day, if there are 10 suits listed before me on the IP division, 5 suits relate to the internet. And piracy on the internet, domain name violations on the internet, they are very complex domain name cases. We have cases where we've ordered domain names and websites to be brought down. Cross-border, the servers are not being brought down. Through VPNs, they are accessible. Crores and crores of rupees are being collected by people through these websites. We have 50 suits pending before me on the domain name matters. Domain name registrars are trying to cooperate as much as they can, but there are some domain name registrars who don't give effect to orders which are passed in Indian courts. They do say that you should get a court order either from US or from Canada, where they are located. So these are the biggest challenges that India is going to face in IP enforcement, because a large number of our well-known brands, well-known movies, music, the violations are on the internet. And I think as normal laypersons, we should now spread the message of not using pirated websites and pirated, content on, because now content is available at such a reasonable price. So I think we should encourage within our country, our youngsters, our children, our youth, to use more of non-pirated content, because let me tell you, India is the biggest producer of creative works, but we earn less than 1/4 of maybe what the US earns from its Hollywood content. So we are at least 4 times in terms of content, but the content doesn't translate into revenues for the economy because there's so much piracy. And I think as laypersons, we are ourselves responsible for it. We need to have a loud and clear message: don't use pirated content. And that would really add a lot of, revenues into our GDP and to our economy. So with these opening remarks, I first request Shri Narendra Sabharwalji to give his opening remarks, and then we move to the other panelists, and then I'll put them a few questions. Yes.
Good morning. Honorable Justice Pratibha M. Singh, Judge Delhi High Court, Professor Rajiv Srinivasan, my colleague from the think tank earlier, Mr. Amog Raya, head of the Innovation Foundation, distinguished participants, ladies and gentlemen. First of all, it is a special privilege to share this panel with prominent dignitaries on the podium, and in particular with the Honorable Justice Pratibha M. Singh, chairperson of this panel, as well as chairperson of IP bench in Delhi High Court. I've had the unique privilege of working with her as a colleague in the IP policy think tank. And I can say that despite what she has told the audience about me today, I think it was she who was always the moving spirit in the policy think tank as well, even though it was finally a product of a joint labor of all the 6 members that we had. So it's a great privilege that today at least we have 4 members of the policy think tank, Justice Singh, Mr. Unat Pandit, Professor Rajiv Srinivasan, and all of we are missing are the chairperson, Prabhasiri Devan, who is in USA, and Punita. But that is to be expected with multiple commitments that people have. But I would also like specially to thank Pandit Unnat Pandit, my colleague, as I said from earlier, for organizing this topical and futuristic conference on nurturing growth of IP-driven knowledge economy. And I thank him for his kind invitation to join this conference. As you know, the panel has undergone a little change since yesterday night. I was told that two of the eminent judges, Justice Hari Shankar and Justice Narula, will be joining us. And so I was a bit nervous, to be very frank with you, that I will be a part of a panel in which there will be three sitting judges from the Delhi High Court, all hands on. And it seemed to me that already they would constitute a special bench of the Delhi High Court. And I was wondering what I would be doing in that setup. And then I thought, why not act as amicus curiae? Now, this idea came to me because a few weeks back, I was attending an enforcement and illicit trade conference entitled Masquerade. You might have attended some sessions of that. That's also a part of what FICCI does. And in the valedictory session, we had the unique privilege of welcoming Justice Vishwanathan from the Supreme Court. And during his remarks, he mentioned two very important things. One about the costs that you just mentioned, madam, which are supplementing the deterrence and the cost that the defendant has to bear in commercial cases. And that he emphasized was a very important innovation on the part of judiciary. But the second thing which he said, and that is what I thought I would do, he said that there are cases in enforcement where you don't want to share information with the complainant or the defendant. So what do I do? Because what do the judges do? Because there is also natural justice involved. There is also the commitment to give all the information and documents to the other side. And that is where he said, we have amicus curiae, the friend of the court. We share that information with him and we leave it at that. And that becomes a bridge in enforcement cases particularly between the enforcement agencies on one side and the accused persons on the other. And that I thought was a very important observation, and that is why this gave me the idea that I might as well do something like that. Now, if I were to continue to think of that as a friend of this panel, I would like to divide my opening remarks in two distinct parts. One, I want to give you an idea of the problem that we are facing. unless we know what is the problem of enforcement of IP rights, what is the extent of counterfeiting and piracy and online piracy, and what are the challenges that enforcement agencies are facing as technology progresses, as new actors come into play, and new dimensions are given to the problem of enforcement. And I think I would like to say a few words on that. But having completed that, I would move on to the policy area, where, of course, Madam, you have already outlined the most important reforms, but I might like to make a few remarks on that as well. Now, let me very simply state the problem first. The menace of counterfeit and pirated products creates an enormous drain on trade industry and the economy. Indeed, on the society as a whole. They crowd out legitimate economic activity and facilitate the growth of underground or gray economy that deprives governments of revenue for vital public services, forces higher burden on taxpayers, and dislocates hundreds and thousands of legitimate jobs, exposes consumers to dangerous, spurious, and ineffective products. And the nexus between organized crime, cybercrime, and terrorism, and illicit trade, counterfeiting and piracy is so humongous and so staggering that it should never be underestimated. Let me illustrate this by giving you a few examples based on international studies as well as studies recently done in the Indian context. Now, the year when we came out with the first IP policy, that was the year 2016. May 2016, the policy was announced, even though we had submitted our report earlier. The estimate which had been made by OECD on the impact of counterfeit and pirated products on international trade was in excess of US dollar 460 billion. That particular figure has changed dramatically. If you extrapolate that figure and the estimates done by certain international agencies like BASCAP and INTA have already done that, this figure has already reached the level of 991 billion US dollars.
Almost $1 trillion.
Yes. So you see the enormity of the problem. Further, it is estimated that the wider social investment and criminal enforcement costs due to smuggling and counterfeiting could touch $4.2 trillion by the end of last year, putting at risk 5.4 million legitimate jobs. Life-threatening counterfeit drugs have been estimated to account for some 30% of sales in some parts of Africa, Asia, and Latin America, thereby undermining the integrity of health systems on a global scale. In the Indian context, till a few years back, I must confess, it was difficult to find authentic studies which had estimated the extent of this problem. The situation is gradually changing, and today I can quote to you some studies which have been done using the latest information and sound research methodology to make the point about what is the extent of illicit trade in India. FICCI Cascade, the movement against counterfeiting and smuggling, has done 3 pioneering studies during the last 3 years. In the first study, they had estimated cost of piracy and smuggling in 5 manufacturing sectors: FMCG packaged goods, FMCG household and personal goods, mobile phones, alcoholic beverages, and tobacco products. And the size of the illicit market was found to be 82,458 crores in the year 2014-15. Again, coterminous with when we were working on the policy, to rupees 2.60 thousand crores, 2.60 thousand crores in 2019-2020. And the estimate of legitimate loss is of 15-16 crores worth of rupees, and the estimated tax loss to government is 58,521 crores. This was the first study. In the last study, and I'm skipping the second study for want of time, but in the last study, which was concentrated on terrorism, high crime, and illegal flow of money, what is generally called as money laundering. The study did a comparative study of 122 countries in the world and came out with very important findings. One of them is that the UN estimates that the global amount of money laundered in a year is estimated to range between 2% to 5% of the global GDP, the global GDP. In the year 2021, the total amount of money laundering in India, as per the estimate, is valued at US $159 billion, showing the magnitude of problem driven by illicit markets. I was in a meeting where industry interacted with the Director General Daren Tang of WIPO, where I used to work some years back. And there, the Film Association, the Music Association, and you mentioned about that also, pointed out that counterfeiting and piracy is leading to a loss of billions of dollars in entertainment, music, and film industry. I was looking at some figures, and studies done by these associations point to a loss of something like 30,000 crores annually, 30,000 crores annually in entertainment and media sector. Add to it the loss, which is the association is not all that vocal, but it is nevertheless very important. The publishing industry. Our publishing industry is very strong, and there, again, the loss is in phenomenal numbers. So these are the extent of problems, madam.
IPR policy, I'll ask you a question.
Yes. Okay. So I'll just finish this. Now, let me just very briefly mention the new areas where the enforcement faces challenge. These are the statistics and the enormity you would have got. One is the e-commerce. And you said very rightly the e-commerce, which is expected to grow to something like 200 billion by the year 2026. There, 1 out of every 5 products is considered potentially to be a fake. Cybercrime, that's another area which I think needs the attention of policymakers and enforcement. The challenge posed by new and emerging technologies, all mostly driven by digital technology, but artificial intelligence and Internet of Things and blockchain and the rest of it, they pose some unique problems, both legal, economic, and I think also ethical, something that our courts will have to finally come to terms with. And uniquely for India, I would mention, apart from the disruptive technologies, the problem being faced by our indigenous communities regarding misappropriation of traditional knowledge. Again, there the problems are unique, and the enforcement is to be done in a distinct manner. So there is a policy point there also. I think our policy mentions about TK, but I think this is something again which is, and you would be surprised. Lastly, I will conclude this portion of my remarks that during COVID-19, whereas in some areas we saw a lot of advancement in innovation and IP-related things, the extent of counterfeiting and piracy, strangely, went up. During the years of COVID, this problem was taken advantage of by counterfeiters and pirators, and whether it is medicines or therapeutics or medical equipment or this problem, and this is recorded. I'm not saying it as an anecdote or lightly. This problem, so you see that at the end of it, the pirators and the counterfeiters and the illicit smuggling traders they try to be at least a step ahead of the law enforcement, whether it is enforcement or judicial system. And the challenge for the policy, for makers, for enforcement agencies, and for the judiciary is to not only catch up, but be ahead of them so that we can prevent them from their nefarious activities. Thank you, madam. I'll just stop here for a while and
thank you, Sabharwalji. You have actually highlighted the reason why we are all there in the IP ecosystem, which is to bring down counterfeiting and piracy. I would now like to move on to our next two speakers. One, of course, is Mr. Rajiv Srinivasan. Some of the words he used to use while we were deliberating in the think tank, I wouldn't even understand. Now I understand them better than then, Rajiv. So, Rajiv, please give your opening remarks. How do you think technology is affecting IP? And what are all the positives that you have seen on the ground in incubators, in startups? And then we'll go to, in the discussion later, about the way forward. Yes.
Thank you, Madam Chairperson. It's a privilege for me to be on this panel here with such high-powered people. And it was a privilege for me, and in fact, an education for me, to be on the IP think tank with Mr. Sabharwal, Madam, and Justice Sridevan, as well as Dr. Pandit and Punita, who's not here today. So my background, I should mention that because it's relevant. I'm not a lawyer by any means. I'm a technologist. So that's part of the reason why our vocabularies were a little bit different, right? I come from a background in technology. I was in Silicon Valley for a long time. And before that, I was with Bell Labs, which is one of the biggest producers of innovation in the past century. But it's fallen on difficult times these days. So I'm, after this industry stint, I started involving myself in academia. So I've been teaching innovation and design thinking at several IIMs as a professor of practice. And there I noticed a number of things that I had not been aware of before the think tank activity, which is the way academia sees intellectual property. There are several problems I've talked to several engineering colleges, including IITs and NITs and so forth. First of all, I find that many academic people simply aren't interested in patenting. They get a lot more incentives and kudos from their peers and from their organizations if they publish. So they tend to publish. Okay, so this is a systemic problem. I don't know if the new education policy addresses that. You should be giving strong incentives to people to generate intellectual property. So that's one. There's no incentive. The second is they have lack of knowledge. They're terrified. They look at IP and say, oh my God, I can't do that because it's so complicated. I'll need to find lawyers and it's going to take years and years of effort. So they just don't bother to do it. So that's a second problem. And the third problem, and I was sensitized to this when I was talking to somebody who had actually got a patent at one of the NITs, and this lady didn't know what to do with it. There were several contenders who wanted to come and take that patent forward and implement it, and she didn't know. She didn't realize that she could actually allow licensees or licenses to multiple people. She's like, how do I give this to this one entity, and so on. So there is complete lack of knowledge, in my opinion, in academia about how to go ahead with intellectual property, which is a huge problem because I studied at Stanford University, and there, for example, there's enormous back and forth between academic people and industry, and they're all creating startups, as you know, for example, Google came out at Stanford, etc. So there is a big gap here, which I think is something that's relevant for the intellectual property community to think about. How do you guys reach out to academia and sort of demystify what the process is? So that's one of the problems I noticed. And then my other job, I was for a while, as Madam mentioned, I was running an incubator for hardware startups in Kerala. This was set up by the central government. I was running it. And there I found a different problem, which is that many of the people who came in were technological innovators or technical innovators. So they had a good technical idea. And in fact, they may, in some cases, have even proceeded to win patents. But then they didn't know what to do with it. Okay, in the sense that they had no concept of how to monetize things. And you're an economist, right? Amok, maybe you'll speak on this. But you have something valuable, but it's like, you just don't know what to do with it. So that was the problem I found with the entrepreneurs, partly because the entrepreneurial mindset only went so far as creating a prototype. And they felt that, okay, I'm done. I made a prototype. Now, why don't you guys come and, Right. And their belief was that once a prototype was there, the world would beat a path to their door. Not true, unfortunately. So the question of creating an awareness and maybe even some mechanism whereby larger companies could come in and form an ecosystem where they would know how to certify products, they would know how to manufacture, and then they would know how to distribute. They may have distribution clout, and not only that, they'd have the brand name, for example. So these are things that I found both on the academia side and on the side of startups that are all related to intellectual property. So as I said, it was an eye-opening situation for me when I first engaged with the IP think tank. For example, I had no idea that copyright violation was ubiquitous in India. We had a person who was sort of a household name. You would all recognize it, but I can't mention his name. He's from the film industry. He came to us and said, look, we know a lot of people are paying the copyright intermediary money when they perform our material, but none of it comes to us. So there is leakage somewhere, which I had no concept of, for one thing. Similarly, we had people from the pharmaceutical industry coming and talking to us, and on the other hand, and they wanted certain, restrictions lifted, and on the other hand, there were people from society, NGOs who said, no, don't limit those, don't remove those restrictions because these are the things that enable the effective and inexpensive distribution of drugs. So complicated issues that we see in many cases that you're more aware of than I am. But the other thing that we were talking about in this panel briefly, both panelists before me mentioned, is what do we do with the new technologies and, as we move forward. For example, generative AI. As you're all aware, chatbots and ChatGPT, Googlebot, etc., have taken the world by storm. But there are some really strange consequences. For example, I was quite startled to hear that the Japanese government has decreed that any use of copyrighted material for generative AI training is allowed. I couldn't believe it, which means the rights of these creators are just wiped clean. As an example, there was also J.K. Rowling, the person who wrote the famous series. Now, these generative AIs can create exact replicas. Basically, they can recreate her voice and recreate books like, we don't need J.K. Rowling anymore, right? So this kind of thing is becoming more and more widespread, I think, and it's going to be a real problem. And then the other part, which is our traditional knowledge. I had an interesting experience in, I was writing an article in a magazine. I wrote an article in a magazine saying that generative AI is not to be trusted to some extent, and I beg pardon of any doctors here, because I said allopathy is based on statistics. They don't have a cause-effect relationship. They have a stochastic rather than a deterministic ruling. That is to say, it works 70% of the time. It doesn't work 100% of the time. Whereas, say, Ayurveda has a theory of disease, and it says, well, because these doshas are in conflict or they're not in balance, then you have these diseases. So allopathy doesn't have that. It just goes by, well, we tried this and it worked, therefore it'll always work. So it's statistical, which basically means that the gold standard for allopathy drugs, which is RCTs, randomized controlled trials, as you're all aware, they don't work all the time. And it's good enough if it works 70% of the time. So what happens to those people who fall into the 30% on whom the drugs don't work? Sorry, right? So there is that problem. And so we wrote an article, a doctor, a friend of mine and I wrote an article. And then we had ChatGPT analyze it. And we made this contrast between Ayurveda and allopathy. And the summary that the chatbot came out with did not mention the word Ayurveda at all. And what does that mean? Ayurveda doesn't exist in its vocabulary because it's got a bias, severe bias. So if this continues, a lot of our traditional knowledge will just disappear. It's not even, it's not even intentional. It's not something that people are doing with ill intent. It just happens because generative AI looks at Wikipedia and Google's stash or Facebook's stash or something. So there is a really strange thing that's happening, which is we may end up sort of disappearing a bunch of our traditional knowledge without our consent or knowledge. So the suggestion that I had made was that we need to build our own AI, generative AI, which can be done incidentally. This is a slight digression. As you're probably aware, there is open source large language models, the ones from Meta. It's called Llama. And Llama turns out to be almost as good as the proprietary ones from OpenAI and Google. It's about 90% as good, whatever good means. So my thought on this was that to preserve our knowledge and to manage to use that productively in future, we need to create in our institutions our own large language models, or else this is potentially catastrophic. So that's one issue of the technology of the future. But there are other things too. Blockchain, as was mentioned, it hasn't taken off as much as everybody thought it would, but it has some very positive potential outcomes. Maybe you may talk about it, right, madam, when you're in your panel. But there's also quantum computing. Now, quantum computing can upset many things. You probably are aware that with quantum computers, your existing cryptography just goes for a toss. It doesn't exist anymore. All your everything that's encrypted is now readable. So things like that are coming down the pike, and cybercrime, e-commerce, those things that Mr. Sabharwal mentioned. So there is a plethora of things we need to kind of worry about deeply that we may not be very much evident today, but they're in the underlying infrastructure for technological growth as we go forward. So with that, I think I will conclude my opening remarks, and thank you again for the opportunity.
Thanks, Rajiv. I want to, this was a brilliant way to introduce technology into IP. I can give a very anecdotal experience of what happened in court one day. There was this lawyer who came up to me and said, this brand is so well known. Look at what ChatGPT said about the brand. So I saw the answer about the brand. And then while we were considering the order, some of my law researchers, one of whom is here, okay, let's put this into ChatGPT and check. And it came out with a 5 or 6 line summary. 3 hours later, while finalizing the order, I said, okay, let's do it again. The answer was different. So ChatGPT is a fun tool. That's all that I can say. But yeah, and I said in that order, that as judges we can't rely on ChatGPT. And lo and behold, a month later, a good friend, Justice Colin Burse from the UK, confessed that he wrote a judgment, and in that judgment, some portions were from ChatGPT, but he read it and he, owned up the authorship of it. So he used ChatGPT to write a judgment. So one is just, surprised that there can be two sides of the same thing. I mean, Justice Burse is one of the most respected IP Court of Appeal judges, and I guess, therefore, they can just be tools, just like a PPT or a Word. ChatGPT is another tool. It cannot replace any of us. Just the way we use an autocorrect in Microsoft Word, this is just a much more sophisticated and refined form of that, I feel. Yes, you want to say something?
Yeah, unfortunately, we tend to believe these large language models, okay, because you may ask a question 100 times, and 99 times it may give you the right answer, so you get gaslighted into believing it works. The 100th time, it'll give you the wrong answer. You'll still believe that's the right answer.
Rajiv. So in one case, the lawyer submitted a brief taken out from ChatGPT in the US, and it turned out that all the judgments which were referred there were fake. So the court returned the brief. So I can only say one thing. For the examiners and controllers here, please don't use ChatGPT. Okay. Now let's move on to a gentleman from a completely different field of our society, an economist, Mr. Amog Rai. I don't know much about your foundation, which is Sanrachana Foundation. He said he has a completely different take on all this. So let's hear from him now.
Right. Thank you very much. I'm going to keep it very, very short. I'm an economist, and like all economists, we are really not asked to make sense all of the time, so this might not. I'm going to take a very different perspective, and here it is. I'm going to make 3 disjointed points and then try to bring them together towards the end. Springer Verlag is a large company valued at $2.1 billion and so on and so forth, makes hundreds of millions of dollars in money. What is it that Springer does? Does it pay the people who produce the research? No. If you were to write for a newspaper, like some of us, most of us here have done, you are given a certain amount of money as remuneration. When you publish a paper, you have to pay money to get the paper published. Before I dabbled into the miasma of becoming an economist, I was a theoretical biologist. Long ago, I had written a paper about population ecology, and I wanted to read that paper again about something. I was told that I'll have to pay 123 euros to access my own paper. It was my stupidity that I did not have access to my own paper, right? So the publishing model on which a lot of this science and a lot of this innovation indexes that we've been talking about over the last 2-3 days is broken. Our university systems are broken because they're inherently reliant on this antique concept of the copyright, right? And copyright needs to change in a very, very big way. I'm an economist of health, right? And it's a good thing that with all of the nutrition and all of the other advancements we've made in sciences, people live longer. But your copyright maxim still stays the same. Is it fair? Is it unfair? Have you asked that question? That's point number one. Point number two. We are living through very troubled times. Last year, Russia decided to get into a conflict, a war with Ukraine. And in 2022, the Federal Ministry of Russia suspended IP of the Western firms, or any firm that it deemed as an enemy country. And now, almost all of those IPs are exclusively available for Russian companies to, for lack of a better word, steal, right? They can use it. Ukrainians are doing the same thing on the other side. This is not a competition between Russia and Ukraine in this, as it can't be. But IP is being used in warfare. What is the protection? Is there a maxim? Is there an umbrella? No, because we've not really thought about it. We think about IP in a limited scope, in a limited scale. And this brings me to the third point. IP is a limited right. It is not a wealth creation tool. It is not property. And one of the most important persons in the field of economics, the first man to really put word to paper and think about economy in a systematic manner, Adam Smith, had some very interesting ideas about the role of property, not covered in his landmark book, The Wealth of the Nations. Before that, he was a moral philosopher. He spent a lot of time thinking about moral philosophy. We need to get moral philosophy back into the markets. I know, as an economist, this is an anathema. We do not really like morality all that much these days. But all of this brings me to a final point about it. This limited right is being asked to solve what it cannot. An intergenerational justice problem, which is climate, which is warfare, which are matters that go beyond regulation and code systems and bringing all of this into the domain of the market, right? We need to redefine and come back to a conclusion of how knowledge is going to come and shape all of this. I agree with everything that has been said in this panel, but I would also like to point out that technology is not the final servitor. Knowledge should be open. Knowledge should be made available to everybody. People have been talking about large language models as an economist. That's something that I work on. I have some very, very interesting points which I cannot make right now, paucity of time. But in all of this, something that we have to remember is that India is a nation where a lot of languages are dying. Languages are going extinct. Can we use AI to protect these languages? And if we do, who owns the copyright? Where does the copyright angle come in? How do we inculcate these technologies into technology as a praxis for good human practices, IP for good, as they call it? In all of this particular thing that is happening, I'll tell you an interesting tale of a village in China called Dafen. So Dauphin is a very notorious village for people who have to, people like the Honorable Justice and Mr. Sabharwal, because
The villains, you mean?
yeah, no, not the villains. No, not by all means. After this, I still have to live in Delhi, ma'am. But so this village is famous or infamous because you could go to this village and you could place an order. You want a Vincent van Gogh? Done. You would want Hieronymus Bosch? Done. They could paint like these painters and then they would sell it. Now, in all of this, is it right? Is it wrong? These are, of course, questions that the courts have to answer, but then there are also these moral questions. A huge part of the world is still trying to make ends meet. And a lot of this can be done by the knowledge diffusion. Now, this knowledge diffusion does not really happen in an equitable manner. So how do we do it? And how does IP come into it? The thing is that we are all, and I am gung-ho about IP, please don't get me wrong. I write a newsletter every Wednesday, or my team does, that is read by 600,000 people, where we talk about the good of IP. But we need to take a larger view of intellectual property. At the end of it all, it is a limited right. Now, of course, I can't do law sitting next to the justice, so I would not even try. But I'll just give you one final example, as I have gone beyond my time and end. My friend Karl Malamud is a very interesting gentleman. He came to India, and then he put all of the Bureau of Indian Standards code for everybody to see. And the BIS sued him, right? And the matter went to the Delhi High Court. And his point was that these are codes of safety which are created on the taxpayers' money, and these are for the use of people. If you want to find out how to make a good house, how to make a good school, you need access to this. Do you think an Indian builder is going to spend 50,000, 60,000 rupees to get the code? No. This matter should not have gone to the court, but the matter did go to the court. The matter is, if I remember correctly, it has just been, they have taken the court case back. I think the government has also taken the case back, but it took 10 years. And that is something that could have been avoided. IP needs to be readjusted in the light of how knowledge is progressing. That's all I have to say. Thank you very much.
So you've all got the most varied perspective about IP on this panel. I think from a judge to a technocrat to a technologist and then an economist who has some very revolutionary thinking, if I may say. So since Amog ended his opening remarks by saying that IP needs to be recalibrated, I'm going to ask him the first question. How do you think IP can be recalibrated for dealing with climate change or for ensuring sustainable development goals?
Thank you, ma'am.
On all questions, 3 minutes.
Okay,
To all panelists.
I'm going to keep it very short. I think that the copyright thing has to be brought out. Whoever has paid the money, most of the copyrighted material in science has been funded by the taxpayers. Be it a private university, be it a public university, it's very, very clear that it's been funded by the science, be it the Department of Science and Technology in India, or be it any European or American body, right? So it should be available for free for everybody to use. We are talking about large language models, and we are talking about a whole lot of stuff, but if you were to bunch together 11 papers without buying them and run data analytics or text analytics, you could technically be sued by any of these publishing companies. I think it needs to go out. We also need to have a comprehensive list of research materials, etc., which is available for everybody as a sandbox. If you create a product which is in the social interest and does not have to make money, then it should be available for free to use. Free, not as free beer, but free as in freedom.
Okay, Rajiv, what would be your views on this?
I may have a somewhat radical perspective, which is that there is a burgeoning movement in technology towards open source, which pretty much, violates everything that is held sacred in the IP world. And lo and behold, open source is quite successful, because I'd like to tell you that almost all of you are open source users today, because all of you have Android phones, right, which comes from Linux, which is an open source version of Unix, which I used to work on at Bell Labs. So that model has legs. It's really transformed the way a lot of technology is built, and the so-called proprietary stuff, which is sort of the paradigmatic, the closed world of Microsoft is no longer working so well. Microsoft used to, own everything, but now I actually live a pretty much Microsoft-free world. I don't use Microsoft products at all, right? And it's possible because there's a lot of open source out there. So I'm not quite sure how this, cohort of IP experts can utilize open source for the benefit of society at large. So that's something I'd like to present as a question.
Sabharwal ji, what do you think?
I think that the basic problem of green technologies and climate change will come from advancement of technology. Because I think substantive areas will need new technologies, new advancement, new thinking, and that cannot be avoided. We can have a lot of adaptation, a lot of mitigation, but technological development is at the base of it. And we have to be conscious that we are creating more and more green technologies. Now, green technologies are not only renewable energy, but these green technologies are a large bundle of technologies which are important, and all of them, from the IP point of view, need to be incentivized. I remember, what was it, the year 2012, I think, when the manufacturing policy of Government of India had come out. And there are 2 paragraphs in that policy, I just recall from memory, that green technologies, Government of India will not only promote, but incentivize. So I think that is one thing. Then the new initiatives which have been taken by international organizations, for example, the WIPO Green, what it is called, is an extremely important green technology exchange platform. Anybody can go there, put the technological advancement on one side, he becomes the seller or the buyer, and on the other side are the people who can use it, they become the acceptor, and there can be a matchmaking or a marriage in that sense. And this is not only happening in WIPO, but in other international organizations, particularly in WHO. This is very, very, very prevalent. So just to conclude also, that there is a climate related SDG, the Sustainable Development Goal of the United Nations, called climate action. And India has done quite well in the index on climate change, because we have a good solar power project. We have good wind energy sector and clean energy. So I think at the end of it, if the efforts continue by the international community, by the national community, technology, coupled with what is important for IP, accessibility and affordability, on the other hand, which provide the balance to technology. I think that is the answer. Thank you.
I must say that with the divergent views on this panel, one actually realizes how many issues need to be discussed before we can, arrive at some kind of an acceptable solution. Let me give you all an example of how IP played a role during COVID-19. All of us know that we were locked up in our homes and we almost forgot what it is to live a normal life. It was the vaccines which made the difference. The vaccines were developed, and I'm sure they were developed at public or private universities, then licensed through licensing arrangements, and maybe a year or so it took, 1.5 years, for the world to be back on its feet. During the COVID-19 pandemic, we all held court through virtual mode. And I recall very clearly from my personal experience that there were a number of matters where petitioners were coming to court. It could be lawyers, it could be for their family members, for their court clerks, for their relatives, juniors, colleagues, asking for medicines. I remember people were asking for remdesivir, for various other treatment options. Those drugs were not available in India. I remember even the Supreme Court making a comment on compulsory licensing, which we were all dealing with in our writ petitions. But I must point out one very positive thing during that whole conversation. The companies which held the IP or which were manufacturing the drugs abroad were also making their best effort to bring them into India at that time. And this is, I'm saying it out of actual experience in court cases where I called those companies and I said, okay, this person needs it. What can you do? So the entire ecosystem was functioning so wonderfully. And I thought during COVID-19, not a single patent was enforced and not a single compulsory license was granted. Which just showed that in India, I can only speak for India, we used IP or whatever knowledge or whatever you may call it, the manner in which it was implemented showed that all stakeholders believed in one important concept, and that was responsible IP. Yes. And that would be the slogan I would think of for the future, for climate change, for sustainable development. Responsible IP. Whether IP is generated in India or anywhere in the world, the IP owners have to be responsible enough to make it accessible and affordable, as Sabharwalji said. Copyright in publishing has to be made affordable for all universities, research institutions to take annual licenses, and the material should be made available. Like I recall during the DU photocopying case, which I was arguing in the division bench, I remember Delhi University was offered a license by the publishers at a very, very nominal cost. And I think this is where the government can step in and say, let's negotiate a license which is very affordable for all our academic and research institutions so that none of this is held back on the ground of copyright. While respecting copyright, we can still make it accessible. So I think responsible as IP is what we should all think of. Whether it's green technologies, it should be easily licensable. Technology transfer should be permissible. It's important to enforce IP, to recognize IP, because that's what satisfies the innovator. I remember in one cross-examination related to a cancer drug, the innovator himself was in the trial, and I asked, what is it that you look for? She said that in a laboratory, when I'm making a medicine, I would want this medicine to reach to every patient in the world and not due to the costs and the high pricing, but I would want it to reach. So the innovator thinks very differently than the way the industry thinks. We need to recalibrate and think of the innovator and then think of how to make IP more affordable and accessible. So I think our session is till 11:30, Unad bhai. I would like to open this for maybe just a couple of questions, but I must warn anyone who speaks for more than 1 minute in a question, I will cut you all off. Yes, please. Just introduce your name and your organization and the question in a precise and a articulate way. Could you please stand up and address your question?
Thank you, ma'am. I did my PhD on intellectual property management. I manage IP, but I also transfer the technology. So my question to both the technologist and also economist, because I am coming from that ecosystem. One side, knowledge must be acknowledged, and knowledge must be managed. So knowledge cannot be free, because we have to respect to an author, innovator, creator, and that is the ingenuity of India, and we have seen from the historical perspectives, that is to Amograji and also to Dr. Chandrasekharan. Technology or IP, normally we believe IP, somebody has a patent, he will get money or it can be monetized. It is very difficult. Yes. So how to monetize a patent in India? Because it is very difficult, because we are not, we do a lot of technology transfer, but we are not, many of the technology what we transfer is not patentable.
How to monetize
Thank you.
patent in
Yes,
India?
thank you.
Either Rajiv or Amol.
Monetizing, I think the problem that I've seen with a lot of smaller companies, it's relevant to what you're asking about, is that many of these inventors really should not go to the extent of productization. They should be producers of intellectual property and then licensors of those properties to third parties. So for example, if you're a large company, you'll have the ability to manufacture, you'll have the ability to certify it, and you have the ability to distribute it, because you have a brand name. Okay, if you're, Suresh can sell 10 of these, but if Suresh has licensed it to I don't know, to take a random example, Philips, let's say. Philips can sell 100,000 of it. So my point there is that people should understand their competence, which is generating IP, and then leave it to others who are able to distribute and produce and manufacture it. That's their competence.
Amol?
Madam, my name is Dr. Rajnikant.
You need to wait.
I just have one very small thing to add to this. See, any patent, you look at the landscape of patent, an individual patent can get you 3 rupees on 100 rupee invested. You have to be a part of a system or a scale-up. Because if you are making something for, say, a mobile phone, then a large mobile phone company will be able to give you that network. We all in economics talk about this network effect. If a patent is outside the network, it is not going to generate any revenue. If it is part of the network, even a patent which is not on very sure footing technologically can scale up in a huge way.
Ye.
Let's have the question from.
Madam, Dr. Rajnikant.
Sorry?
My name is Dr. Rajnikant. I am from Varanasi.
There are
And,
other people who are having questions.
Pardon?
You can take it offline, please. Yes, Dr. Unad Pandit, you were saying something. Yes, so one we've done from there. Yes, yes, please.
I have just cleared my law and entered into IP litigation, as well as I'm also patent agent. So my question is regarding what solution do we have in case of, like, if we want to promote innovation in AI as well as we want to prevent copyright infringement. For example, there is a class action suit in US recently, a class action suit which is against ChatGPT because they are using the copyrighted books and the other text of the authors or the books all over the world. So what solution can we provide in such situations where we want to promote innovation in AI, for example, ChatGPT and other tools, as well as we are to prevent copyright infringement of the other authors as well? Thank you.
Who would like to take that? Rajiv again.
I teach a course on innovation and I teach a course on design thinking. So I address both sides of it. One is the innovation aspect is how do you take a brilliant idea, say IP, and take it all the way to market and make it successful. The other side is how do you understand what somebody needs, what there is a market need for, what are the unmet, unarticulated needs of people, and then build something to that. So in this context, I think if the ChatGPT, pirates are meeting the need, then you got to figure out a way in which that can be done while compensating the people whose rights are being violated. And I'm not sure there is any legal mechanism in place for that, but I'm just saying you got to balance the interests of both parties.
Mr. Sabharwal has a remark.
Thank you very much. I just want to touch on what was asked about monetization, commercialization, and also on the IP aspect of artificial intelligence. There is no easy answer to what was asked about monetization. There is a whole objective in the policy which deals with strategies which can be utilized to commercialize and bring your innovation to the market, which area will apply to which fact is something for the innovator. But I agree, and this I have been emphasizing, that this is a weak area. And this is the most important area because unless you can monetize, you can't create wealth. So I would request everybody, particularly CG, to have some tools and some research on how we can promote commercialization and monetization. On the IP and AI, I would only like to share the information that this is an area which is, as I would say, and people say that, is work in progress. There are no definite answers which you will get. It is a work in progress, but a lot of debate is going on in international fora, particularly WIPO, where there is a dialogue going on practically every 2 months. And the last dialogue which I attended from here online was the 28th dialogue in the series, dealing with what are the implications of IP and artificial intelligence. I would request people to go onto that portal, join that conversation, and it is free of course, it is not, you only have to register, and see what is being said by different countries in different circumstances. Thank you.
Anyone from that side? Yes, the gentleman here.
Good afternoon. I am Gauri Datta Sharma. I am a mechanical engineer and I entered the IP field very recently, 3 months back. So when I was studying the patent, that the patent office, when it examines an application, when it looks at the inventive step, there are two things, the technical advance and the economic significance. And I do not know if the analytical figures on whatever patents are granted during a year are the releasing figures stating how many of the applications were granted and how many on economic significance. It will be very interesting to know why economic significance is more than the technical advance today.
Okay, I can answer that very briefly and say that in the statute, economic significance is an or. It can be technical advance or economic significance. And I'm sorry? Or both.
Or both, yeah.
So I don't think the controllers or the examiners would be putting them in those slots while granting it. While I'm sure we can have an AI program to analyze it and give you the data.
Okay.
So I think we are coming to the end of this show.
Just to add to this, the United States Patent Office has a chief economist. I think the Indian Patent Office also needs to have an economist. And because economists are very notorious for not working with anybody, until as they're called by titles.
I didn't know that Mr. Amog Roy had a hidden agenda coming on this panel. So I think Dr. Unnal Pandit needs to note and please get an economist on board quickly. So, yes, please.
I'm Dr. Meera Sharma. I'm an immunologist and been to IPR since last 16 years. And I have followed few of Thank you. I have followed few of the judgments which are given in SEP patent infringement in which are listed with SEPs. Now my question to Rajiv ji and yourself is that is think tank planning for having any SEP policy in India and laying down the guidelines for patent infringement which are listed with SSOs? This is my only one brief question, please. Thank you so much for giving me this opportunity.
Okay. Neither do I. So I guess someone from the government will have to answer that.
So
I don't think
I
any
think
of us can answer
I think
that
this is a
question.
big gap. I think we should address to.
Everyone in the hall has noted what you're saying.
Yes. Thank you so much, sir.
So I want to ask one last question to Sabharwal ji. Do you think, sir, that the IPR policy has achieved what it wanted? Or do you think the IPR policy needs a 2.0?
Madam Chair, I certainly think that the time has come for National IPR Policy 2.0. The policy, when it was made and promulgated, since then, very substantial progress has been achieved. And there is no denying, because those are, that is reflected in the figures which are coming out. Such a lot of number of patents, trademarks, filings, research, so many. I mean, it is mind-boggling. 4,000 outreach meetings have been held, etc. I don't want to get into those figures. So these are not mean achievements, and I would commend all those involved in these achievements wholeheartedly. Having said that, we can look at the review of the policy A by looking at the pace of implementation and the gaps in implementation of the old policy. Now, that is not very difficult. There are areas which have not been touched, and those can be taken up. And there are areas where the pace has not been up to the mark. That can be done. Then, during this period of 7.5 years, so many new developments, some of which we have touched here, so many new developments have taken place, which ought to be conceptualized in policy framework. And when we take these two areas, I think the need for a relook and review of policy is obvious.
So one thing that has not been touched upon during this entire session, which would have been the focus if my colleague judges were here, was the IP division of the Delhi High Court. And the scrapping of the IPAB in 2021 resulted in the establishment of the IP division. And for all those you need to know as to what is happening in the IP division, please go on to the Delhi High Court website. There is an annual report which has been published this year with the data, which would show that almost 50% of the patent appeals which came from the IPAB were disposed of within the first year by the Delhi High Court. And In the field of trademarks, copyrights, the statistics are between 35 to 50% because they are larger in numbers. The Delhi High Court IP division is getting almost 800 to 1,000 fresh cases every year. And we are having 2 dedicated judges currently. Earlier even we had 3. Due to the strength having been reduced, it was reduced. And after us, we have a specific framework for dealing with IP disputes. Even patent rules are drafted. They're all available on the internet. And I must say that the Madras High Court has set up its IP division, and it's doing extremely well. They gave their recent decisions on 3I and some of the most important areas of law. So I think the IP divisions, as the parliamentary committee has recommended, that all high courts should have an IP division. If that happens, I think the IP enforcement ecosystem in our country is going to be completely changed and will be different. And I really enjoyed today's panel. Thanks to Rajiv and the ballistic Amogra, and to Sri Sabharwalji with his, traditional, conservative, and, nuanced thinking. This conversation can go on forever, but I really thank all of you for patiently listening to all of us, and I thank my co-panelists for such a wonderful presentation and interaction today. Thank you.
Thank you very much, Madam Chair. Thank you very much.
No more, not right now, sorry.
Thank you to the panel. Thank you all the panelists on dais. And we here move on for the session 2. Thank you so much.
Dr. Pandit, please join us for a big picture. Excellent, nice to meet you. You have a card?
Somebody took my bag. Who took my bag? No, I need to take something out and give it to these guys. Okay. Hi. Sorry? Oh, just my. No, I had my bag. Sorry? Yeah. Yeah. Shall we? Yeah. Yeah, come with me. What happened to my bag?
सबसे पहले क्या रहेगा? सबसे पहले ये रहेगा सीनियर डायरेक्टर ऑफ रिसर्च।
क्या चल रहा है ये सब?
अब होगा सेशन, अब होगा, मतलब दूसरा सेशन स्टार्ट होना है तो लोग बाहर चाय वाय पीने जा रहे हैं क्या?
नहीं, चाय कहाँ है?
चाय है नहीं। प्रोफेसर डॉक्टर Not on the screen?
No, screen में डालते वक्त.
Okay, okay, okay. Vasudevan ma'am, yes ma'am. Miss.
CEO Nicole.
Okay, okay. And MD of Deutsche Bank.
Yeah, just say Sanjay was the former MD of Deutsche Bank. That's good enough.
Okay,
Because
okay,
I had got 6 roles.
Okay, okay.
Global,
I'd like to.
APAC.
7 years will be given. Do the brainstorming, and I'll be saying that you were humble enough to be. Because I remember I took your media bite last year also.
Hanji,
So I was humble enough to was part of this conference last year also, and this year she again is with us for to do the brainstorming.
Okay.
And
You can see she was the former MD of Deutsche Bank and also Thomson Reuters because of information knowledge.
Sure, ma'am, sure. And also,
Thomson Reuters. वो छोड़ दो. उसके बाद rest of it is fine.
sure, ma'am, because CG sir will say you didn't introduce ma'am properly.
नहीं क्या होता है CEO I had 6 roles.
Right, right, right.
One was a global head of something. There was another one which is divisional something.
Sure, sure, sure. Also Thomson
Thomson Reuters.
Reuters.
Reuters
Okay.
was the news.
Yes, ma'am, I remember.
Yes,
Thomson
वो
Reuters.
हो जाएगा. That's
Okay.
fine.
Sure, ma'am.
That takes care.
This will be enough. Okay. Hello. 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 हेलो सर जी, आवाज़ नहीं आ रही मेरे फोन। आवाज़ नहीं आ रही मेरे फोन पे। आप यहीं पे आ जाओ, मैं यहीं पे एंकरिंग वाली पोजीशन पे खड़ा हूँ, हॉल नंबर 6 में। वर्षा, ये कैन आई आस्क मैं बात? प्रोफेसर नशीद देसाई। Yes, ma'am. सुनो कोई बात, बोलो। बंद कर दिया, बंद कर दिया, बंद कर दिया, बंद कर दिया, बंद कर दिया।
अब मुझे क्या
हाँ सुनो, तुम्हें कोई दिक्कत नहीं है, डॉक्टर काजल वाला मैं संभाल रहा हूँ, वसुदेवन वाला मैं संभाल रहा हूँ, इन दोनों में कुछ बोलो। आवाज़ अभी भी आ रही है पीछे, ये फिर कितने चलाया? पीछे आओ, पीछे आओ।
I request all the guests and dignitaries to gather in the hall as the next session is just about to begin. A humble request, please gather at the hall because the next session will commence very soon. We are going to start very shortly. It's a humble request. Please, all of you, settle down and we shall begin the next session, please. A humble request to all of you, please gather at the hall because the session is just about to begin. We would like all of you to settle down. A humble request to all of you, please gather at the hall. We are going to start the session very soon. All of you are requested to kindly settle down for the next session, please. all of you are requested to kindly settle down. We are going to start the session. I request all the dignitaries, the guests to kindly settle down. We will be starting with the session very shortly. With the end of this exhilarating session, we now move on to the next session for today. We've had some illuminating discussions about responsible IP and recalibration of IP, making IP affordable and accessible in the previous session. Now we move on to the next session. Firstly, greetings to all the esteemed dignitaries. I would like to welcome you all to this conference today. As we all know, if the opportunities and challenges in IP administration is not discussed, the purpose of the conference always remains half fulfilled. And who else can better chair this panel than our Honorable CGPTDM, Professor Dr. Unnat Pandit Sir. CG Sir has been looking after the Indian IP administration since the past few years. I'm sorry I cannot stop myself, but there are many laurels to his. I welcome you, sir. I would like to invite my colleague to welcome our respected members of the panel for today, please.
A very good morning to the honorable dignitaries. So, with this exhilarating session that has just concluded, we have come to the concluding session of this IP conference 2023. As you all know, this conference is about the opportunities and challenges in IP administration. And this IP conference, without discussing the challenges and the opportunities in IP conference, would be half complete. And who else would be better to chair this panel other than our Honorable CGPDM Sir, Professor Dr. Unnat P. Pandit Sir. A huge round of applause. And I know, sir, but one thing I like to add, as we are all settling in, post-COVID-19 times were the times when the world was going through huge turbulences, and along with that, all the offices were also going through huge turbulences. And that was the time when Sir was given the charge of Indian Patent Office. But as we say, as we all know, that the vision of our Honorable Prime Minister is Aapda Mein Avsar. So vis-a-vis to that idea, Sir took the challenge, and today IP office has taken heights which were unfathomable. Now, since we have a paucity of time, coming on to the panelists we have, first of all, I'd like to introduce you to Miss Sandhya Vasudevan ma'am, former MD of Deutsche Bank, and I'd like to, please come on the, okay. Ma'am, please come on the dais. A huge round of applause for ma'am. Ma'am is humble enough, she was with us last year also, and this year again, she is with us. I'd like to request V. Rekha ma'am, Joint Controller of Patents and Designs, to please present the souvenirs to ma'am. Yes. Next, I'd like to request Professor Nishit Desai, sir, to please come on the dais. Professor Nishit, sir, is a BSR Fellow, former Dean of Science Faculty, MK Bhavnagar University. I'd like to request Dr. Usha Rao, ma'am, Deputy Controller of Patents and Designs, to please present the souvenirs to sir and welcome him in this event. A huge round of applause, please. Next, I would like to request Dr. Mohit Gambhir, sir, to please come on the dais and grace us with your presence. Sir is a former Innovation Director, Ministry of Education Innovation Cell, Government of India. I'd like to request Dr. Sweta Rajkumar, ma'am, Deputy Controller of Patents and Designs, to please present the souvenirs to sir. A huge round of applause, please. Finally, we have Dr. Bakulesh Khamar, sir, to please come on the dais. I'll request him and grace us with his presence. And I'd like to request Srimati Rishu Bharti, ma'am, Deputy Controller of Patents and Designs, to please present the souvenirs to sir as he graces us with his presence. A huge round of applause, please. A huge round of applause. Now, with these words, I would like to start this session on the note that yesterday our WIPO DG sir said one thing about India, which I would like to say and take my leave from here. Sir said that India has one of the most unique innovation story to tell, and we can tell the innovation story from Aryabhatta to Ayurveda. Thank you.
Thank you all for your active participation in the National IP Conference. This is an important session wherein it is not going to be just the panel discussing from the dais, but it is the session wherein we are going to have a voice of the conference. And without the participation from this side, we will not be able to strategize what should be the action item out of this IP conference. And while we have discussed in a various sessions, the secretary and the distinguished panel in a breakout session and in the plenary hall also. Now, this is the time wherein we have to break the barrier and unlock the opportunities. We need to strategize the way IP administration is functioning, the kind of a reforms or a revamp which we all foresee, and in order to have the conference theme, nurturing growth of IP in knowledge economy. So it's a role of each and every one in this hall. What kind of responsibilities which we are going to carry on our shoulder. And this responsibility is going to drive the entire IP ecosystem, supporting to build the knowledge economy. And while knowledge economy is the vision, government has already clarified, even in the budget speech also, FM has mentioned that technology and knowledge embedded economy. and 140 crore population in Bharat, and the youngest population is expecting a lot from the scientists, from the technocrats, creating a new innovative solutions. And this new and innovative solutions will lead us to the technology embedded knowledge economy. And while we are doing it, so IP is the magic key to enable this. We have a distinguished panelist. Sandhya ji is from the banking sector. Nishit sir is from the academics. In a remote location, in a small district of a country where he has created the IP-driven ecosystem. Mohit ji is having the academic background. He was in the Ministry of Education's innovation cell. So connecting almost AICT's 15,000 plus institutions, institutional innovation councils. And Dr. Kamar is from the corporate. He is inventor in many products, and you may have seen few products also in the exhibition. So this session is going to have the interactive discussion on the dais and off the dais also. And to begin with, I will invite Sandhya ji for the opening remark, and then we will start the interactive discussions. I have a few points in my note to discuss, and then we'll also open the session. Again, I will go by the judgment given by the Justice Pratibha Singh ji, 1 minute, 1 question. And we'll also follow the 3 sides. Those who have not occupied this side, chances of getting the opportunity is fair on this side. So over to you, Sandhya ji.
Thank you, Najji.
Yeah.
Thank you, Najji. I was here last year, and this is my second time here. Let me start with congratulating Unajji and the team. I think you had the Minister, Piyush Goyal, talking about how much progress and how fantastic the team has been in driving change. You had Mr. Shri Sanyalji, who spoke about it as well, apart from the DG, Mr. Daren Tang. So I think you can't get better recognition as a team for having accomplished what you have. I think what was also very heartening for me was to see the continuity of we have to be one of the best in terms of systems processes to take it forward. I think that was another message. But what I really honestly was touched by was the fact that you're going to be leveraging Mera Gaon, Mera Dharovar, and linking it to IP and taking the transformation for Indic knowledge and the knowledge which the country has. I know even before he took on this role, he was talking about what could be done there. So for me, I think those were 3 immediate takeaways. Very quickly, I think the conversation around commercialization of IP. I'll share my example from Thomson Reuters days. Every IP in Thomson Reuters was mainly based out of Switzerland. So which meant that I could be doing the work in India, I could be doing the work in New York. The revenues could be coming mainly from any of the global places where we operated, but the IP was owned in Switzerland. So when I look at the Global Innovation Index and see Switzerland on top, large businesses have established their space for owning IP in regimes which have been very convenient and supportive of them. So we are in that journey to make that happen. We heard a lot of those conversations on the commercialization. But I'm going to probably ask Rajnikantji, Unaji later on, maybe you'll be asking him to share his perspectives. And he was talking about what can we do in the context of GI and the farmers who actually create a lot of our country's IP, and we don't fully take that up for action. So maybe I think that was one thing that I picked up. I think there were one or two other people who spoke about it. The other one that came up was with MSMEs. Again, it's an idea from one of the people in the crowd, and if you can speak up when you get the chance, it'd be great. It was for the ONDC. When small companies get onto ONDC, Amazon is already doing it, making sure that they get the copyright or any of the requirements from IP perspective. We should make sure that we are able to give them the IP Mitra support, any kind of financial support around that, so that more and more of the smaller companies can get the commercial benefit which they can get out of that. I think the only other thing which I will call out is large, let's say the banking sector in the GIFT City, IFSC, has already incorporated the concept of IP into their framework. Therefore, while it is taking a bit of time for the financial sector to put out more IP opportunities, you're looking at the fintech sector, which is going to be contributing, almost 1.2 trillion in terms of the AUMs towards the economy. And you're looking at that and saying, how much of IP are they creating? Because it is the backbone, and we need to make them really aware of the possibility of how can you unlock that potential. So I think I'll leave it at that. There could be other perspectives, but I'll just leave it with these.
Thank you. Thank you, Sanjay ji. You have touched upon an important point, and the IP Mitra support for MSME. This is something, IP Mitra is the term which was given earlier. It was IP Facilitator, and SIPP program has been a pioneering now. So many startups, academic institutions, and SMEs and the individual inventors have been benefited out of this. The scope may be reviewed, and will take up this message. I have taken a note in my action item for the discussion with the DPIIT. But the SIPP program, which really helped the individual creator and academic institutions. So now I would like to move to Professor Nishit Desai ji. Can you, sir, share your experience on protecting the IP from the government academic institutions and kind of challenges, and what should be the importance on IP which you feel it? Yes, sir.
Yeah, very good morning to all of you. At the very outset, I would like to express my thanks to Professor Ramnath Pandit, who has provided me an opportunity to share my views as an academician. So let me start with the 1997. So I started the IP program in the university in 1997. At that time, there was nothing like atmosphere of IP in the university structure. And one of my colleagues, Professor Piyush Goyal, is also sitting here. He is the pioneer for starting the awareness program of the IP in the university structure. So in the sixth pay commission was introduced in the by UGC in the university, and the sixth pay commission, the special focus was given on the patent filing, copyright, etc., etc. And that was the turning point in the academic institutes. So then when you go for promotion, previously it was like that, everybody is talking yesterday about the publications, but then in the 2010, the sixth pay commission was introduced, and then sixth pay commission, during that time, focus was given to filing the patent, copyright, etc., technology transfer, etc. And then what happened, there is a drastic change amongst the academic institutes. And then what happened to see, in our university, what we have constituted the IP cell. And then again, with the help of the IP cell, and even Professor Ramnath Pandit and Professor Ganguly has helped us to frame the IP policy. So now what happened to see, when we frame the IP policy, and then we have started the awareness program. So with the help of awareness program, there is awareness amongst the academic fraternity how to file the patent, and even the university structure. They have given the separate fund for filing the patent, etc., etc. And then even in the seventh pay commission, again, there is a much more weightage is given for filing the patent, etc., etc. Then in 2020, new education policy is formed. The moment new education policy is formed, There is you can find the innovation cell is introduced, incubation center is also it is also developed in the university, and Atal Incubation Center is also. You have a lot of funds for incubation center, and this is how there is a drastic change, and academic fraternity is aware about filing the patent. Of course, we have a lot of problem for filing the patent. Once we file the patent and once the patent is granted, then there is a much less awareness about the monetization, or less about the commercialization. So what my observation is, industry should come forward for helping the patent taking forward for the academic fraternity. This is how challenges, a lot of challenges are there. Academic institutes should join the hand with the industry people. But there is, I think probably industrial people, they should also change their mindset, because they are not changing their mindset, and they personally feel that there is a a breach of confidentiality, and this is how they are little bit afraid of joining the head with the academic institute. These are the couple of challenges. Of course, finance is also there. The patent office has reduced the fees for filing the patent, etc. This is my opening remark. Thank you very much.
Thank you, sir. Certainly, the 75% fees reduction has boosted the patent filing, and even the initial time getting the official patent fees paid, the file is moving from the section to the registrar, and registrar to again section, coming to the department. It takes a few months. So this was the reality. When I was in the academic institution, this has been the challenges, and we all are facing this reality. But now situation has improved, and the kind of a 75% fees reduction, even the individual inventors from their project fund, they can take care of the IP related expenses. IP Mitra has also benefited, while the official fees and the honorarium or a token of appreciation is also getting reimbursed, and so many attorneys have come forward to voluntarily support. This may be the patent agents CSR, I can say that, giving back to the society. And I will now turn to the Mohit that on academia and industry. So I have academia and industry both in my right. Mohit, can you share your opening remarks with your experience as a professor of practice from IIT Jodhpur, and then previously with the innovation cell?
Thank you so much, Professor Unnat. And जनरली लोग बोलते हैं मेरा देश बदल रहा है, मैं बोलता हूँ मेरा IPO बदल रहा है. और it is evident, like where we have seen, I was part of last year, but I was not able to come down, so I stay in US now. This year I am here, and frankly it is mesmerizing to understand and know that whole event is managed by Professor Unnat and the whole IPO team. Kudos. So that was the first voice of conference before even I wanted to start my remark. Now coming to the major issue from the academia, what has to be done, where we are. I belong to a kind of mixed breed as an individual in a way, because I started as an academician, moved to corporate, became an entrepreneur, again moved to government, handling a lot of stuff. So I've seen inside, outside. Professor Desai just now mentioned that industry should come over and join hands. Maybe I'm taking some pointers from Sir, and it will be really difficult for the last candidate. It is always the last candidate because all the pointers are over. So now here is a thing which I need to touch upon. The researchers in academia, they genuinely need to channelize their research. Please, and it has been discussed, I believe, over the course of yesterday as well. Even today morning, I was talking to someone. It is not to boast your CV. Please understand. It is something which has to do with country's economy. It is something which has to do with our future. IP is not a joke. Please do not make mockery of it. And to the facilitators who are sitting here, I am also one of the facilitators. It is our moral duty to look into it. just for the sake of putting in IP, sake of filing it, please guide them, please spread awareness, please educate your peers why IP is important, and when IP is not important, rather filing patent is not important, IP is always important. So to sum up, we have to get up and under the advisory of Professor Ganguly, Professor Unnat, we all made a kind of system at IIT Jodhpur, and because it is the recent one, I would like to highlight it. So what we are doing there, anyone who is submitting their synopsis for PhD, we sit, we discuss, and immediately we tell that fellow to go and do the prior art search along with an expert's help, right? Prior art, then state of the art and everything that's been done. The researchers, they are being provided with a few weeks or so to improve and improvise. They come back again, and then they move for provisional, right? System is, we are trying to develop a system, a culture, not a system, a culture. Because culture, if it establishes, system by default will establish. And do not take any offense, I primarily say, with all of us, problem is not about knowledge, problem is not about learning, problem is to ease. Morning itself, I gave someone this formula, it's ethics and ethos, which must turn out to ease, right? It will eventually. So just follow this, and I would like to sum up. Maybe in the continuing discussion, I'll come up with more pointers. Thank you so much.
Thank you, Mohit. Really, in a very short opening remark, but you have emphasized on a mindset change which is required to have the effective IP creation from the academic institution and in general also for all the SMEs, MSMEs and the people who are not used to dealing with the IP or research or kind of a literature search also. But now I would like to move to the Dr. Kamar. He is himself is having a few hundred patents and then a seasoned researcher, I can say that, and have developed many products. So, sir, over to you for your opening remark.
So, before I start, I'll say that by training, I'm an eye surgeon, not a researcher by training. And I have been faculty for quite some time, maybe more than 25 years in academics as a professor in medical college. And now I'm part of an industry. And few innovations which I did in the early part of the career were done as an academics and not as an industry. Now, when I look back and start looking at what was told yesterday in the morning, my take is like this. See, we are, as a country, we are known for jugaad innovation. What does it mean? If there's a problem, we find different solution which is not known, using whatever is available to us at that point in time. Now, if you translate into the IP creation, what are the things? First thing is, I am aware of the problem. As a person, I am aware of a problem. I am also available to the resources which I have. And then I find a solution. Now, if you apply this in terms of IP, majority, I have been interacting as an academician and as an industry with various publicly funded organizations for identifying what can be taken forward. Like everybody says, interest is not coming forward. But we have been proactively going to the academic organization since '98. And we are trying to look what we can do, and what we are trying to look at is it a disruptive innovation or an incremental innovation? And where does it stand in view of what is currently available? And in pharmaceutical industry, it takes time. It takes around 10 years, in our country, little more, to get to the market. And when we come to the market, what will be the scenario? And where does this innovation stands in that scenario? Because we can't produce something, waste our energy and resources to get something which has no value in the market because there are better solutions available. So our impression is that majority of our academic organization, they are not aware of current standards. What are the current gold standards? There is a diagnostic, there is an investigation, or it is a therapies. So unless you know the problem, unless you know what is a gold standard, you can't do something better, because everything you need to do is a better. You can do incremental research and get a publication, but you can't do incremental innovation and get a product to the market. And industry will not be interested in that. You have to have something which has a value. So having said that, I mean, I will stop here and we will take some questions. Is that okay?
Yeah. Certainly, sir, there should be a value in the research which should come out of the hard work, because research is not just the piece of a patent certificate or a publication in a well-reputed journal, but it has the investment from the public fund. In majority of the scientific research in India is the public funded research in academic institution. And it is, even beyond that, it is a hard-earned man hours. And equally for women also. I am not having any bias. But the kind of manpower and the hours and resources which is getting invested, the output may be negligible, but its commercial use is important. And that's why the growth of IP for the knowledge economy is important. The commercialization, we all say that, and Sahuji has also touched upon the monetization of IP. Why this is not happening? I would put reverse. Are we prepared for the monetization? And then I think I have reframed his question, same question, but are we prepared for the monetization of IP? Then if answer is yes, then industry will come forward. But for that, we need to have a robust technology transfer docket. Each and every quality parameters which are expected at least for the pilot of the research. Pilot study is essential to go for the commercialization. We cannot bypass this. Huge investment is going to occur. So this too, if the answer is yes, then certainly industry will come forward, and we have seen certain projects also in exhibition that even hydrogen generator from the green hydrogen generator from the biomass is the classic example. All the parameters, everything is set. Each equipment, its entire process, everything, each aspect of the technology transfer and quality is mapped effectively. And then industry also came forward for the pilot, and now after pilot they are going to scale up, and they have already installed the scale up plants in the industry to convert the biomass into the green hydrogen. Same thing from the effluent, they are converting into the hydrogen. So this is equally the opportunities are available, but answer is no. Then what kind of essential research and the quality aspect we need to develop to make it to the commercially applicable? And while we are doing it so, general perception globally is that it is a singular TRL 1 to TRL 10, the one scale monitoring, and majority of investment gets failed because of the singular dimension assessment of technology. We need to have a three-dimensional assessment. If we imagine the three-leg table, one of the leg is a TRL, the two other leg is a commercial readiness level and the societal or market readiness. If the cost is not meeting to our research is a robust, first time in world, but it is a few 10x, 20x of the cost, then it is naturally not going to survive. Cost aspect, that's why the second element, it should be at par with the available solution in market. And third aspect, societal and market aspect, if this is not essentially meeting the market need, where market is having a sufficiently available solution, but there is no space for the new entrant, then also it is going to fail. So IP monetization won't survive if all the three legs are settled, and the IP which is on the top, if one of the leg is weak, IP will fall down. So this may be the answer for Mr. Sahu. Now I would like to open, again I will follow the three patterns. Yes, sir.
Can I? Okay. So, he mentioned that, you should have a document ready. But, I'll give an example that is not always so. I'll talk about one European small biotech company with which we are working. It is a output from a university in Europe. They have some fantastic finding. The compound which they found to be useful for a particular disease, I can't reveal so many things, but that compound was stable at minus 80 degree. Okay? Nobody can think of taking that product forward. Who in the world is going to develop a product which is stable at minus 80 degree and has to be available whenever needed? Okay? We joined hands with them, and that's where industry comes in. We like the idea. We said, okay, this is good. Eventually, it is likely to be a good product. We made it stable at 2 to 8 degree, and that's where industry comes in. Minus 80 degrees centigrade, 2 to 8 degree. Okay? We changed little bit of chemistry, we changed little bit of formulation, lot of iteration, which cannot be patented, but we are done. And that's where it is now moving forward. Eventually, within 2 to 3 years, it will enter the humans. So we are not looking at ready. I'm just trying to make you understand. If it is disruptive, that's what I said. If it is disruptive, we go all the way out. If it is incremental, we evaluate along with what is available. Because what is your incremental value? I have a 5 rupee note, you have a 7 rupee note, incremental value is 2 rupees. And then to gain that 2 rupees, I'm going to spend 5 years and so much resources. And at that point in time, my 5 rupees will become 10 rupees and your 7 rupees will be 7 rupees. So that's a business sense we take into consideration. So I think this will help everybody.
Thank you. I think much simpler way he has explained. Yeah, from center, we will now begin. I will also have questions from the back. So can the volunteer please help with the microphone? Yeah, this side in front. And then you can stay back. Yes.
Thank you, Dr. Pandit. I just had 3 suggestions, taking clue from Dr. Gambhir and Professor Pandit. One is that we are a country of 100,000 startups. I think that's the estimate of 2023. We've done sufficient, promotions for women inventors, universities, SMEs, everything. Maybe it's a good idea to look at providing a prior art search facility in-house by the IP or something similar to what I think UK does, where at a very nominal cost, individual inventors, SMEs who cannot go to larger companies and yet can have their innovation protected, at least get an idea. That's point number 1. Second, sir, we spoke about, Professor Pandit spoke about monetization and commercialization. And I think I've been working on this project for a very long time, something known as IP trading. It's a very old expression used in the industry. Singapore, I know, has a very good model of a IP trading platform exchange, where you have a platform created for everybody, where you list up your IP there and look for potential licensors or somebody who wants to take up. It's a very big model. You can have models at the international level and also at the national level, which suit your economy. Third, sir, is changes in the law. because most of the innovation which we are now looking at is generative AI, medicinal diagnostics, things of that kind. So we will also have to look at a conducive legislation to ensure that things which may not have been possible many years ago is a change that we really need to now look at. Lastly, it's more nothing to do with IP, but as a woman practitioner, I do feel that diversity is a very integral and an important part, because it does, and I'm not talking of getting women, or diversity means ethnicities, things of that kind. It does bring in different perspectives from different fields and domains. So those were some of my suggestions. Thank you, sir.
Thank you. Very valuable suggestions. Certainly, the prior art search facility is, I think it is essential, and but not by the IP office, but maybe the RGNI IPM can support this, because I believe that IP office is going to offer a search, there will be a conflict of interest. And I don't want to get the innocent inventor land up into this kind of conflicts, and it will invite some question on the administration. So, but certainly the trained staff from the RGNI IPM can help them and groom them to do their search in the manner it is to be done. Because majority of a IP search, if search is not accurate, then we will end up into some other island where we have not aimed to achieve. And this is the problem also in India. And I would like to turn to the Mohit. I think he is the person who can better explain this. He has experience, and I know some examples he have. So Mohit, over to you.
So, thank you so much, Professor Unnat. Out here.
It will.
Yeah, it becomes. Yeah. So I was waiting for the sensor to sense my voice. So that is what I always say. And again, on a very lighter note, इस दुनिया में IP भरी पड़ी है, खोज लो जितनी ऐसे इधर उधर पड़ी है ना? सुबह से शाम तक भरी पड़ी है. Just a sec, I need to answer the questions. So first thing, like Professor Unnat Pasun, prior art search, and I'm sure many of you must have sensed it up, we need to educate our clients as well. We need to educate the diaspora. The situation is, what we do, people, they come in and they ask what it will cost. Search रहने दीजिए, draft कर दीजिए. बहुत लोग हैं जिनके साथ ये स्टैंडर्ड इशू. तो कहीं ना कहीं मैम ने जैसे कहा कि बैक एंड पैटेंट ऑफिस फैसिलिटेट करे, I 1000 times second Professor Unnat, no conflict has to be there, because people then will jump on and say कि आप ही ने तो किया था. Right? It is not the business of, but on the contrary, guidance can certainly be there. Suggestions can always be there, which people can take up. Second question ma'am का था IP exchange के बारे में. तो I'm sure you must have gone through Hong Kong IP exchange model. Failed. Why? We need to answer. So another thing which I bring in, I will attach it to your third question. Laws need to be changed, right, or amended. I'm attaching it. I'm clubbing them up. I have one issue always. Why we try to look west or east? Why can't we look indigenous? Why can't we frame our own laws and show people that this is something we are doing? I'm being very, very vocal about it. I'm being very, very vocal, and you can see the pitch and the raise in my voice. We have to frame our own thing. We have to be creator. We are not here to do services and co-creator. Sorry. Thank you so much.
I think world is also following us as far as the legislation is concerned, and the Lex judgment sharing with the WIPO Judicial Institute. They are going to take all our judgments on record to teach the other IP offices and their judicial system as well. So this is going to be the example which is set. And the MOU is also signed. So this is something which is going to be there. Now, this side. Yeah. Sorry, I will take this side. Miraji, I will invite you. I have notice the lady in front. We will take front first and then back, okay?
Hi, afternoon
This
everyone.
side now, just get yourself ready, yeah, okay.
Afternoon everyone, greetings to the esteemed panel. I'll just make it very short, I understand we're short on time. I'm Shivarthi Bajaj and I'm the founding managing partner for RSD Bajaj Global Law Firm and personally leading the IPR and emerging tech practice. So, sir, my quick question, under your able leadership and the governance that, we are having as a country, we've really ironed our practices in the past many years. But in the point of view of the domain names and the deep tech that is coming up, and the few judgments that Pratibha ma'am also spoke of earlier today, how do you think as a background to everything, the IPO will have to maybe align its practices or how we as practitioners or at the policy level, contribute to aligning this more so that there is less friction in the whole process as a whole? Thank you.
If you recall, we have invited the practitioners' opinion on framing the policies, suggestions for the already available guidelines. And I'm quite open on inviting the suggestions, had a few one-to-one individual meetings also, open house meeting, group of attorneys meeting also on our patent rules. And now for taking this momentum forward, that whatever guidelines we have framed, I am told in the office that in 2011 this guideline was formed, it was never revised. So research dimensions got changed, economic dimensions got changed, then why not the guidelines and the policy and manual be revised? So I am of the view that we should be revising these guidelines, practices and the manuals for better clarity to the patent practitioners and the researcher, both. So that what is going to be the scenario, it can be appropriately conveyed through this document. And in the IP office also, many a time I have communicated and we are still working on this to develop the habit of citing the manuals also. Manual citation is important because that conveys the way this interpretation has been derived, and that is going to help all of us. This is our honest efforts, and slowly, steadily this change is going to brought into the practice. We have established the quality cell also, so that quality of examination and quality of a hearing and the order can further be improved. So this is our, and your suggestion is well taken on framing some guidelines. Please make a written submission, we will take it up. Yeah, this side. Yes.
Hello.
Microphone on ही रखिए तो अच्छा है.
Hello sir, my name is Hon'ble Goyal. I'm associated with Motherson Innovation as a patent counsel. So I'm taking this comment from our yesterday's session where we discussed about the IP commercialization, and today also briefly we discussed about that. And the challenges, as you said, that there are resource challenges, there are cost challenges which the product is not able to cope up with the already available market. So the thing is that the individual contributors or the individual inventors who are inventing or who are filing the patents, where they will get the motivation to file these patents if they are not able to monetize that, if they are not able to commercialize that. So recently, like what I have seen on various platforms, that whatever patents are granted, the inventors, they are just taking it as an advertisement thing that, okay, my patent is granted, and they will get the accolades from their colleagues or friends. And maybe another achievement would be added into their resume maybe. So apart from that, what else they can utilize their patent for?
Certainly, this is a challenging question, but I must submit here that wherever there is also a mindset issue that whatever the patent which I have got, I should get few crores of my royalty and licensing fee and all. So this is also a mindset issue. Pardon me if I am straight coming on the dot issue, but if we really feel that it is of a worth commercializing, then we should offer this to the SME, MSME who are desperately in need of a new products, new inventions, and they are going to work together with the individual inventor to develop this as a commercially successful offering from the industry. So this gap is there, and I think it is high time that we recognize that there is a value of IP, and we should come forward, both the side, SME, MSME, and the individual inventor to join hands. In Israel, there are individual inventors who are establishing their one-man show startup. And then they develop this entire product and they out-license this to the corporate. And each individual and the royalty arrangements and the licensing mechanism is designed in such a way that both have a win-win opportunity. And this royalty terms or this licensing mechanism and this kind of a valuation matrix is IP practitioner's job. They need to understand this. They need to not just be the lawyer of drafting the contract, but help them understanding the value and potential of their IP. And one or two such success case is going to increase the royalty value also. Sure. So this need to be understood by the individual inventor, and I think then we will be in position to slowly, steadily, कछुए की गति से आगे बढ़ना पड़ेगा. But हाँ, आगे बढ़ेंगे तो जीत निश्चित है. ठीक है. एक क्वेश्चन हो गया, अभी इनको भी मुझे न्याय देना है. सॉरी, 1 मिनट आपका हो गया था.
थैंक यू.
भाई मैं जजमेंट वायोलेट करूंगा तो आई विल बी इन ट्रबल. ठीक है ना. वहाँ येलो ड्रेस में मीरा जी आपका सेंटर में है, आपका नंबर. आपका भी आएगा. जिस
Myself, Dr. Seema Goyal, I have studied about right to privacy. Whether intellectual property rights need to be protected from the perspective of right to privacy. And our youngsters are not aware about their rights. So what we can do to ensure our youngsters that their rights will not be violated? And in case of violation of their rights, what steps should be taken to protect their rights? Whether there is any robust data mechanism to protect our privacy rights in respect of our intellectual property rights?
I think match is going to start at 2 o'clock, but I will keep this as a bouncer to
Sir,
right
please,
to privacy.
sir, please. Sir, I think everything that is part of our life is attached to our privacy rights.
And sorry,
and I think
have a helmet also.
Sir, I think intellectual property is the creation of our mind, and that is the part of our life.
Ma'am, I have understood.
Yes, sir.
And on a lighter note, see, everyone is very serious, so I have thought that some smile and such. So I will turn to Mohit, who is also a practitioner.
Sir, please.
He will help me in this. So he's the next 10 batsman.
So situation is, see, when we say, and many of the things, ma'am, what you asked about right of privacy and other stuff, as an attorney, I believe many seasoned and learned attorneys are here. The very first thing they honor is attorney-client privilege, and there is no such kind of like personal or privacy thing is going around. And for as an inventor, or the thing what you ask is, ignorance of law is no escape of law. We also have to like educate ourselves where we are heading, what you are doing. By default, you download the apps and so many private informations what we shoot up on the, without even asking. But when we come on to this IP thing, then we start asking those questions which are not supposed to be asked, and we do not focus on those things which need to be asked. Another, just an add-on, attorney-client privilege, and this particular point is very close to me. A lot of people, they were discussing chat GPT, generative AI and everything. My take on that was very simple, and many people do not agree with me, that when my client has hired me and gave me something to search upon and discuss upon, it gives me no right to put on the ChatGPT engine and the information, because I don't know, like in the previous session it was that within 1 hour, Justice mentioned, Honorable Justice mentioned, within 1 hour it got changed. I don't know where my information, or my client's information per se, I'm putting into black box. So a lot of privacy things, but food for thought. Thank you so much.
And secondly, by ignorance also, we agree to certain terms. And the interpretation, we have never understood that this is going to land up into the situation where there is a no man's land. So that is also there. So I think here the IP practitioners need to help the individual creators and artisans and the inventors to ensure that their rights are well protected, and the information which is getting shared on internet, certainly the security challenges which are there, and in previous session also Honorable Justice has mentioned that internet is really a serious challenge which we all are going to face. Currently we have already started facing, and it is going to increase. It is like entropy. But we have to safeguard ourselves, how we can be effectively protecting our privacy on internet. Thank you. Meeraji, and then you. Yes. I know that center is having a large amount of...
Thank you so much, sir. I am not going to ask any bombarding questions. I'm just going to congratulate Dr. Unnat Pandit for various reforms he has brought into the functioning of Indian Patent Office, and that has really helped us as patent agents to get more and more IP protection. Thank you so much, sir, and we look forward to even more reforms. We are very optimistic about it, along with your very aggressive team. And another one, it's a pleasure to see Dr. Mohit Gambhir here. For me, it's an honor actually. And why? Because he started hackathons. And incident, sir, congratulations. My daughter, she participated in an hackathon, she won it, and she got the patent granted, and now it is on the process of monetization. So this is my personal experience which I'm sharing with you all. Thank you so much.
Thank you. The credit for the reform is not to me, to the team who is working. I'm just ensuring that they have a sleepless night in my team. So they are always geared up. I have to add the fuel in the belly, which is also already firing, and they are working tirelessly. Certainly the IP team who is doing all this. I have just tried to put the right person at a right place. That's only the work which I have done it. But certainly the team has a huge amount of energy, the potential which is already there. I have just tried to utilize their potential into the right direction, and that is the result in the kind of a change which you are seeing in the office. And still there is a huge potential in the office, and we will try to bring these reforms in the administration, in the kind of rules amendment and the act amendments also. I must submit that whenever you feel that this is to be amended, don't wait for any notification from the IP office inviting the suggestions. It's a 24/7. Whenever you feel it, yeah, this idea strikes to you and it is useful for the kind of a reform in the IP office, just send the email or letter. We are sincerely going to review them. Thank you. Yeah, that's it. And then in center and this side.
Thank you very much
Welcome
for
to the
giving me this opportunity. I am Dr. Preeti Taide. I am a researcher and IP facilitator also. What I found that only top 5% people in the world, not in the India, are actually utilizing IP in the way that innovation, protection, monetization, and once again going back to the research. But most of the people we are landing in the medium level, we are having a great potential to innovate, invent from childhood also, being incubation center mentor, I found that. But nowadays, what happening, this IP is becoming CV boosting technique for all these people, because other than that, they are not using. What is my opinion in particular, when we go across the WIPO courses, we found some less stringent IP availability, such as a utility patent, trade secret, and when I tap into the existing legal and all existing practitioner, I found that these things are not there in India. Now what happens, these mediocre people can't directly jump to something which is beyond their limit. They found that it is overwhelming. So I'm not talking about the utility patent exactly. I don't know what is that can be. But one step, if in between is landed between this with respect to time, with respect to money, with respect to the criteria, the stringent and very critical, if they are lower little bit, then some people will at least try to land on that step. And then further, we have to make the habit in the society to protect the IP. Once if it is goal which we cannot see, we cannot climb. See, we can go to the Pachmeri and go to that Chauragarh, but we cannot directly go to the Everest. So for the common people, it is the traveling to the Everest. So I think we must do have some Chauragarh.
I got the question. I think it is high time that we recognize the potential in the IP protection. Utility patent may be one of the means to protect. What is this utility and how much is the protection and what kind of advantages which the inventor are going to get it? It is a matter of a discussion, and we are internally evaluating all the prospects and possibilities, and this has been in the discussion to introduce the utility model protection or not for quite few years. But now sincerely the team has started accessing this from the available information and the given reports, inputs, wherever the utility model has been implemented, or even the patent registration which was also there, what is the benefit? Because offering the IP right without any kind of enforcement possibilities or opportunities to earn the revenue out of the IP is something which is not going to be beneficial. So we are more sensitive towards offering an IP right which can lead to some protection, and utility model is one of the way, but we would like to see that Indian model of the IP protection. We don't want to adopt which X, Y, Z countries have done it and we want to replicate. No, we don't want to replicate this. That's why it is taking some time in accessing the potential for the utility model and the benefits which we should be offering to the rights who are going to protect their inventions under that. Thank you very much. Yeah, I will go to this side now. And then the back. And the last.
Good afternoon. Good afternoon, everyone.
Yeah.
Can you hear me?
Yes.
Okay, I'm Gauri Datta Sharma. I'm a mechanical engineer and I have a background in sales and marketing. So I want to make a suggestion and I want to ask you if this is possible. Can we not have a bridge between the researchers, the inventors, and the market? The market is the industry or wherever. And I look at the patents as an asset because we have to monetize the asset. When we can sell products, why can't we sell assets like IP? And if there is a bridge this bridge could be a statutory entity or it could be an entity formed by the industry. For instance, CII or FICCI can make an entity, and this entity evaluates each patent in terms of marketability or saleability, and then stamps the patent and says, this is the percentage of potential in this patent for saleability. And then this is recognized and then implemented. Can it be possible?
Sandhya ji, can you, as a banker, I think she can do the justice to this question. But it will sensitize on that.
Not just as a banker, but I think working with a lot of startups and organizations that support startups like TIE or CII or FICCI, I think one of the things that we find is go-to-market is definitely, what you called out is absolutely a factor. Maybe we should work with Unnatji's team to see how we can create specifically on the IPR side of things. I think there's value there. I think linked to that, one of the things that you find with startups is if you're an Indian startup, the amount of effort you put in the go-to-market to get 10 rupees versus going to the US to sell, it's far easier to get the $100 than to get the 10 rupees. So if you're looking at something like that, I think we need to think through what is the market you're looking at as well. I think in the earlier panel, both Mr. Srinivasan and Amograi had mentioned we can partner. But again, I find it's interesting because there was one we were looking at. A young university student in the US was looking at the tumor markers using breath analysis for lung cancer, which you're going for a monthly checkup, you can easily get that done very easily. He was trying to sell it at 200. If he goes to the big guys, it would have become easily 20,000 or maybe impossible for the average man to get. So what's the role, especially in India, we have been very conscious that it needs to be accessible to everybody. So I, as an IPR owner, the support from TIE and others is how much can I monetize versus how do we make it more democratic in its access? I don't know. I mean, we can work with it. Definitely we should work with it.
I would turn to Professor Nishit Desai ji also. So many important IP assets are getting created in academic institutions. And monetization aspect, I think, sir, if you can throw some light.
What you are telling is totally different things. See, we have different models. You are talking about the research institute, there this model will not work out. No? If you are talking about industry, then may be possible that this model will work out. Like, even in, say, for example, CSR Institute. So CSR Institute, what the researchers are never involved in DBM, the selling process. No. So the role of researcher is to, identify to develop the novel things, and then it will go to the IPR division or IPM. This is what you first listen me, and then if you have any problem, we'll discuss in detail. We don't have any problem. So, because patents are not filing by only industries, patents are filing by research institute, universities, and all other institutes. So a lot of IITs are, now they are selling their product. Even CSR Institute, they are also selling their product. And this is how, their BDM department is completely different. So in that case, probably for industries, maybe whatever the thing you are telling, that may be possible. But for other institute, I think probably, because see, scientists are busy for their own activity. And this is how, it is very difficult. Even in university structure, what I have developed the product, that product was given to the entire thing was given to the IPR cell, and then IPR cell will take the responsibility of filing the patent, etc., etc.
So I'm not talking about.
I would like to add upon what Professor Desai sir has said. See, CSIR, there are 37 labs, and each lab has several scientists working, and they are trying to identify the problem which has the societal relevance and commercial value. And equally the basic research which they have to do it. But centrally, they are managing this through their IP team who has developed this expertise, and they are becoming the bridge between the research and the market. And this is something, and every such institution or a group of institutions should have their IPM management team. It is their job to manage the research and IP creation and teach the literature search and identifying the relevant prior arts to the scientist, so that whatever they are doing, that can be avoided as a duplication of a work. On a lighter note, what we were discussing last evening, I would like to use the example of a Mohit, which he has experienced, not I have experienced, but and Professor Ganguly also, that one research team took almost 18 months to identify one relevant prior art. And it was a pain for them to identify this, and they have put in so much of a man hours in identifying the entire prior art, and then they found that scan, and they have found that these are the relevant prior art. And then within 3-4 minutes, these prior arts got identified with effective search tool and search string and the platform which is available. So, and it is publicly available, yes. So, we could have saved this many number of hours or a time, and we could have straight away jumped to the action if we have found out this effectively. So, these are the gaps which is still there in the system. It's time to identify. There might be several other gaps also, but we can identify them, address them, and put a more time in an investment in utilizing the potential or working to the real problem, which can bring the solution. We can have the discussion after this also. This is a very long topic. We can have a discussion, debate. But I will go to the last person in this row and then here in the third row. I know there are going to be several questions, but we will have often discussion also. Yeah, please.
Thank you, sir. One question to the banker actually. The banks, why I'm saying this? Because it's very rare to see banks promoting or investing in the IP or promoting in some way. So is there any policy with the banks available wherein they can promote the MSMEs or the individual also in promoting their IPs? And secondly, to Nisit sir, since you are from the academic side, I have also witnessed one reluctance in the academia that if we say that, as Mohit sir also said, that you first go and do the prior research, prior art search and then go for filing. But what I find in academia, they are just pushing forward that we have developed something and you have to file it anyhow. So how to convince the professors and the academicians in this regard? This is the major question.
Yeah, really, sir.
So now in the academic institute, if you want to file the patent, you should know the parameters of filing the patent. It's not like a state where you can go for search or like that. So when you develop new product, and if you feel that this is complete new product or this is my new invention, in that case what happened to see, should have a clear-cut idea about the filing the patent, 1, 2, 3, 4, 5 steps. So even we never said that you filed just patent. It's not like that. You open the switch and immediately you can get the light and then you close the switch and it is closing. No, it's not like that. So in the academic institute we are very serious and we are spending the money for filing the patent. No? So it's not like that just to develop the product and file the patent.
See, one more submission to Professor Desai sir. It is never easy to convince the professor. But it is your job to convince them. So academician and industrialist, I will also turn to Dr. Khamar.
I mean, you can play devil's role or you can be
or you can be one of the, garbage in, garbage out. So if professor wants to be filed, you file it in whatever form he wants, and then the patent office will reject it. It will be timely death.
As a medical doctor also this answer.
If I may add, sir.
Timely or delayed, that we will decide.
If I may add, sir, what the data also suggests that most of the patents that are filed from academic institutions are not taken forward also. Like if it is once filed, the FERs come and it is not being prosecuted further. So this is one of the major problem that I also see.
I beg to differ here, because those applications which are filed with Form 18A, they are getting expedited. The examination report is also, now we are more alert, vigilant, and then we are having a benchmarking better than few developed IP systems. Our FER is getting issued in 4.8 months in majority subject. And normal is a 6 months, and few developed ecosystem have 12 to 15 months. So this is the benchmark. So we have improved, and we are still committed to improve on this. On banking question, ma'am.
On the banking side, my first response was going to be why. But then I thought that was a bit of a flip question. I think the gentleman earlier said, we need somebody to assess the commercial viability of a patent before the bank actually give you. Banks are there to give you a business loan. They're not there to give you grants. So if you have a proper business plan by which you can make money, which makes sense for the banker to provide you with funding, they will definitely do so. Otherwise, you have other sources like your angel investors and the entire full ecosystem of startups who will provide you, provided the idea is commercially viable. Otherwise, no, people don't just give money. It has to be commercially sensible for the returns.
Yeah. As far as the academic research is concerned, I would like to make a submission that there are soft loans also available. There are several programs which are run by the Government of India under DST, DBT, even if they are a small enterprises, MSME ministry is also having program, PSA office, Agni initiative, Atal Innovation Mission initiative. So many, the research has a potential to commercialize, and it is addressing the gap which is there into the system. So even I will again go to my previous submission that in trial table, if you analyze the potency of this research, if it is meeting the societal need, it has a commercial potential, and on technology readiness level also it is sustaining, then you will get the funding from the government sources, and people will also invest into this research. Thank you very much. Now from center, yes.
सर आपने भी क्रिकेट की बात करी थी, तो मैं आईपीओ के लिए बैटिंग के लिए खड़ा हूँ, इंडियन पेटेंट ऑफिस के लिए इस बार। और सर हर बाउंसर का मैं जवाब दूंगा।
अरे वाह
सर, एक्चुअल में
तो अभी अंपायर भी बाउंसर का जवाब देंगे।
हाँ,
ये नया ट्रेंड शुरू है, हमारा इनोवेशन तो यहाँ पर ही है।
सर विद ड्यू ऑनर टू जस्टिस एम प्रतिभा सर, उन्होंने बहुत सारा डेटा दिया हमें आज, नो डाउट अच्छा काम हो रहा होगा, मैं भी ये मानता हूँ। बट सर अभी रिसेंटली आईपीओ ऑफिस के लिए जस्टिस हरिशंकर और मैम का बड़ा स्ट्रक्चर पास किया था उन्होंने कि गो बैक टू स्कूल एंड लर्न दिस एंड दैट। सर मैं चाहता हूँ कि आईपीओ ऑफिस टू वे ट्रैफिक है सर, उनको एक सजेशन दे सर, एज अ डेटा का सर, स्टैटिक्स का सर जो कहना है कि इट इज़ जस्ट लाइक अ बिकनी, इट रिवील्स इट कंसील द वाइटल्स एंड रिवील्स द सजेस्टिव, इट इज़ व्हाट इट्स अ प्रॉब्लम। सर हम लोग जब जाते हैं, रेड्स होती है, इन्फ्रिंजमेंट होता है, हम लोग जब जाते हैं सर, कोर्ट कमिश्नर हमारे साथ होता है, मैम का ऑर्डर होता है, जस्टिस का ऑर्डर होता है। जब हम थाने में जाते हैं, सच्चो कहता है भाई के है, ये क्या ले आया तू, ऐसे सर मैं फैक्ट्स बता रहा हूँ आपको, मैम का ही ऑर्डर है गाजियाबाद का, सर एक फूड राइपनिंग का एक इन्फ्रिंजमेंट था, भाई क्या ले आया तू? मैंने सर ये जस्टिस दिल्ली हाई कोर्ट का ऑर्डर है। क्या तो मैं क्या करूँ? मैंने सर हमें थोड़ी सी पुलिस प्रोटेक्शन चाहिए, हमें वहाँ पर रेड डालनी है, हमें सीज करना है। कांस्टेबल दे दिया उन्होंने जो लाठी लिए जा रहे थे सर। एंड दैट इज अ गुड करोड़पति कि हम फैक्ट्री के अंदर जा रहे हैं सर, वो हमें क्या करेगा कुछ नहीं, भेज दीजिए इंस्पेक्टर कुछ तो चला जाए। तो उसने सर हमें भेज दिया। अब सर हुआ क्या कि उसके कई इंस्टॉलेशन थे सर, एक पे हम जैसे पहुंचे उसने बाकी सबको बता दिया, सब अलर्ट हो गए, गायब। सर व्हाट आई वांट, कमिश्नर के लिए, कोर्ट कमिश्नर के लिए और एसएचओ के लिए कुछ एसओपी होनी चाहिए। आप सजेशन भेजिए विद ड्यू रिस्पेक्ट।
Certainly, आप रिटर्न सबमिशन दीजिए। We will have a discussion in government. We will see, check the
Sir, there is no SOP.
possibility.
नहीं, समझ में नहीं आती सर।
SOP के से ज्यादा एक भाई ऐसी तो करोड़ों SOP है हिंदुस्तान में। SOP से ज्यादा भी एक माइंडसेट बदलने
सर
की
एसएचओ को नहीं पता क्या होता है कॉपीराइट।
नहीं, पहले तो मैं वहां आता हूं कि SHO का क्या ये काम है, आप समझिए। मतलब क्या SHO क्या
सर जब इन्फ्रिंजमेंट की रेड डालने हम जाते हैं कोर्ट से ऑर्डर लेके,
भाई मैं यही कह रहा हूं कि एक such kind of a commercial dispute or a raid should be dealt by a different division. There are specialty division established in the various state jurisdiction. State Home Ministry has a commercial wing who is doing this. And being from Gujarat, I know in Gujarat this is being dealt by the commercial wing of the state. And they are dealing with this. They are supervising, monitoring. If somebody is having a grievance on the approach, they can reach out to them. So this is something which is very much doable. Now, how to bring the element of a system in process? That I think appropriate legislative change, if you feel it appropriate, please do make a suggestion. Government will have a review. We are open to have the suggestion on any such important element wherein we need the reform into the system. And this is quite a useful submission that we will have to look into this, because such, you can sit please, such kind of changes which is essential into the system, we should bring it wherever an appropriate enforcement mechanism is essential. I take the suggestion from the previous session wherein Mr. Sabharwal has made a submission. It is a high time for a National IP Policy 2.0. And in National IP Policy, I can say second avatar, the time has passed, 2016, now 2023. Many initiatives got realized on ground, many are implementation challenge, and few are yet to be implemented. But implemented when? So it is a high time to implement them with strategic call which government need to take it. And again, it is required to have the two-way discussion dialogue on what should be the national IP policy in the Amrit Kal. If we have to achieve the growth of IP, nurturing the knowledge economy, and we need to ensure that research really deliver to the expectation which country is having and society's grassroots challenges which we can address. I think each and every one need to take a responsibility on our shoulder, which I have made a submission, again I am repeating, that if we all want that India should be the developed economy, then knowledge driven approach is the proven economic reforms which we have seen, that unless we realize the potential of a knowledge, unless we respect the importance of a knowledge, and IP creation, respecting the IP is equally important. society need to learn. That's why all the copyright related issues, patent related issues, trademark related issues which you have pointed out. E-commerce is also having the challenges. Why the pirated products or marks and the infringing material is getting sold on e-commerce? Who should be the liable? These are the open questions, and these questions need to be addressed in a way that offers the strong IP regime to the creator and inventor. And for that, we all have to gear up. We need to strengthen the ecosystem. Honorable Minister has also mentioned in his submission, his talk, that this is the time to build the IP regime as the country moves on Amrit Kal. And the kind of reforms which is happening, it's a witness that we all collectively need to work together to build this ecosystem. Knowledge economy is something which we collectively need to build in. Last year also we have had a brainstorming, series of a brainstorming. This year also we have had a series of a brainstorming on the substantially similar title of the conference. But I firmly believe that IP is the key to open the doors. And if we collectively, all the practitioners and professionals and IP administrators work together, we can open the doors of the opportunity for the knowledge-driven economy. This is something which was the message as a take-home. You don't need to say what is going to be your role in this, but collectively you decide your role, what as a IP practitioners or as a IP administration or as IP officer you are going to play in this journey towards the Amrit Kal. That will be the biggest resolution for this conference, after this conference, and you decide your goals. But whatever goal you decide, it should offer a benefit to the society. Thank you very much for joining this. I have got the message from the team who is looking after the food arrangements that food was hot. Now they are again trying to make it hot, but do justice to the food, and also food for thought is also there. So you all can join us for the lunch. Thank you very much. Oh. Thank you.
Thank you so much, Vinodji. I will see you whenever I see you.
I'm liking to listen back. It was long due, but whenever I'm planning, maybe November.
So I mean, see you.
Bags. Bag.